House will come to order. Those persons not having privilege of the floor will please vacate the chamber. All members and guests in the galleries will please rise as we are led in prayer today by the lady from the 19th, Douglas Kraus.
Thank you, Mr. Speaker. Heavenly Father, as we begin this session today, we come before you and humble our hearts, asking for wisdom, clarity, and discernment in every decision we make. Guide our words so they may bring understanding and steady our minds so we may serve with the integrity and purpose. Help us to listen with respect, lead with courage, and work together for the good of all the people we represent. Grant us the patience in disagreement, unity in service, and spirit of humility as we carry out the responsibilities entrusted to us. May our actions reflect justice, compassion, and genuine commitment to the well-being of our state and its future. In Jesus' name we pray, amen.
Amen. Please remain standing as we are led in the Pledge of Allegiance today by the gentleman from the 45th District, Delegate Brooks.
Thank you, Mr. Speaker. Colleagues, guests, please join with me as we give our pledge to our flag. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Members and guests may be seated. Reading of the Journal.
Journal of the House of Delegates, February 9th, 2026.
From the 72nd, Douglas Riley.
Thank you, Mr. Speaker. I ask unanimous consent that the further reading of the Journal be dispensed with and that it be approved as having been read.
From the 72nd, ask unanimous consent that further reading of the Journal be dispensed with and that it be approved as having been read. Are there objections? Are there objections? No objections are heard. Introductions. Introductions. From the 55th, Douglas Akers.
Thank you, Mr. Speaker. Over here in the North Gallery, you have a young lady named Katana Curry, who you're going to hear a lot more about later on today with regard to House Bill 4749. It's the Foster Child Bill of Rights. She also has with her a couple of her caseworkers from Daymark, Allison Harris and Oakland Miller. And then Marilyn Hall is also escorting her and has helped her help usher this bill through the House this year. So you hear more about her story in a little bit. Thanks for being here today, Katana. Thank you all very much.
Thank you, Mr. Speaker. Joining us today in the South Gallery from the heart of West Virginia and Barber County, we have Allegheny Metallurgical President and CEO Perry Longacre and CFO Jared Mount, joined by our Secretary of State Chris Warner. Allegheny Met is a true West Virginia success story, investing $1.2 billion and employing 465 West Virginia miners and extracting and exporting the finest met coal available, making the steel that builds the world. Please extend them a warm house welcome.
Gentleman from the 23rd.
Thank you, Mr. Speaker. Ladies and gentlemen, it's homeschool day at the Capitol, and I'm happy to have a bunch of homeschool families who just went through a mock committee meeting. They're all in the North Gallery. We're going to have the Chapman family, the Scott family, the Schweitzer family, another Chapman family, the McCormick family, the Wright family, and my family. If they would all rise, and the House will please make them feel welcome.
Mr. Speaker.
Thank you, Mr. Speaker. We have lots of guests and friends with us today, but we do have some from Central West Virginia. I'm pleased to welcome them here today. From the Calhoun County Commission today, we have the President of the Calhoun County Commission, Eric Lapardis, up here in the West Gallery. We also have Commissioner Lee Rush. Supporting them is our County Administrator, Jennifer Randolph, and our County Sheriff of Calhoun County, Graham Knight. They're here talking about some things that are important to some of our smaller counties today. And we do have a number of pages today. A number of us will be introducing our able assistants that are with us today. I'm pleased to welcome from among our page program today one of my neighbors, Eric Zane Wilkinson, and his service dog, Corbin. Eric's a student at Elk Valley Christian School and Marshall University. Please make them welcome today.
Delegate from the 92nd.
Thank you, Mr. Speaker. I have the honor today to recognize a couple of very special students from my district who attend Hedgesville High School. Hedgesville High School is in Big and is also one of this year's Jennings Randolph Award winners. The school is represented here today by their honorary secretaries of state. Seated in the South Gallery here today with Secretary of State Chris Warner are Caitlin Hall and Julianne Hatterer. I would ask them to please stand and have the House make them feel welcome. Thank you.
Gentleman from the 53rd.
Thank you, Mr. Speaker. I'm delighted to recognize a constituent of mine, Dennis Farrell. If you'd like to stand. He is the father of Amelia Nicely, and as I have seen from firsthand experience, the most committed volunteer at the monthly Rand Community Center hot dog sale, which is the first Saturday of every month if you'd like to attend. Please make him feel welcome today. Thank you.
Gentleman from the 60th.
Thank you, Mr. Speaker. Joining us today in the South Gallery, have a couple of gentlemen here that work with the Co-Association to help keep the lights on and, more importantly, during this winter, help keep the heat going. A couple of gentlemen representing AEP, and that is Leonard Price, if he'll stand, I think, over in South Gallery, and his colleague Cody Lusk, who's also one of my constituents in Sissonville here in Kanawha County. And they're joined by my former colleague, Erica Storch. I think she vacated on me, but Erica had brought them in here for us today to see. So I appreciate everybody and hope you give them a warm welcome.
Gentleman from the 84th.
Thank you, Mr. Speaker. Today I'd like to introduce you to my youngest son and my grandson and my granddaughter, Craig Jennings, Blake Jennings, and Evelyn Jennings. If they would stand, everybody.
Gentleman from the 46th.
Thank you, Mr. Speaker. Delegate Canterbury and I have one page today. If he will stand down here. It is Gatlin Elmore. He is a 6th grade student at Eastern Greenbrier Middle School. He's joined by his grandmother. She'll stand in our gallery, Lori Bazare. Will the House please give them a wild and wonderful West Virginia welcome?
Gentleman from the 61st.
Thank you, Mr. Speaker. I have a large group here today with me from Elk Valley Christian School serving as page. They are students from Mr. Wilson's government and history classes. Today we have Micah Petrie, Natalie Hudson, Madeline Jones, Caitlin Standiford, Shayna Jeffries, Sammy Tucker, Spencer Campbell, Connor Rush, Addison Shin, and two that you may recognize names, Derek Petrie, which is the grandson of our doorkeeper, Mike Stone, and Ryan Armstead, nephew of our former speaker, Tim Armstead. They are escorted today by Mr. Wilson, their teacher. If you would stand and make them feel welcome.
Gentleman from the 86th.
Thank you, Mr. Speaker. Good morning, everybody. I also have the honor today to recognize a couple of special students from my district who attend East Hardy High School. In the South Gallery, and when I mention names, stand up. East Hardy High School is in Hardy County. It's also one of this year's Jennings Randolph Award winners, and the school's represented here today by the Honorary Secretary of State seated in the South Gallery with West Virginia Secretary of State Chris Warner are Silas Sheetram and Albert Lermanu. And they are, just hold the applause, they are also joined by the Vice Principal of East Hardy, Jessica Baker. Albert is accompanied by his mother, Sandra, and his brother, Aiden, and Silas is accompanied by his father, Stephen Sheetram. Please make them feel welcome.
Gentlelady from the 19th.
Thank you, Mr. Speaker. I have a couple announcements today. First, I have a page today, Victoria Sobey, if she'd stand up. She is accompanied by her mom up in the South Gallery, Nancy Ibrahim, I hear Victoria is an amazing violinist. I hope to get to hear her one day soon, and I know she's wanting to become a lawyer. If the House could please make her welcome. Oh, okay. Next, yeah, that's what I thought. Next, I would like to welcome homeschoolers from across West Virginia. We have over 25,000 homeschoolers across our beautiful state. If they could all stand up in the galleries. Please make sure to talk to them today and welcome them. And for all the homeschoolers out there who are on the treasure hunt today, the password is in red. In red is your password. I figured this was the easiest way to get it to all y'all. If the House could please make all the homeschoolers welcome today.
Gentlelady from the 63rd.
Thank you, Mr. Speaker. In the North Gallery, I have a couple of constituents up there, homeschoolers and just all-around special people, with Lance Linden and his family. Stand up and wave. And Mariah Frame. It's so good to see you guys. Thank you.
Gentleman from the 73rd.
Thank you, Mr. Speaker. I have the distinct honor today to recognize a couple of very special students from my district and from Grafton High School. The West Virginia Secretary of State's office hosts the prestigious Jennings Randolph Award for Civic Engagement each year. This award is designed to recognize the state's high school students for their student-led involvement in West Virginia's voter registration process, and the principal of any high school that earns the award is eligible to then nominate 2 students who are active in the voter registration effort to be recognized as honorary Secretary of States. Grafton High School in Taylor County is one of this year's Jennings Randolph Award. Grafton High School has also won this award 2 years in a row, and where they have had 100% registration among their students. So it is my honor today to recognize these 2 students, along with our Secretary of State, Chris Warner. As I have, let's see here, Miss Addison Nethkin and her father, Chris, and Bryce Eisner and his mother, Sharon. Would you all please make them feel welcome? Also, I also have up there, and we also have our Taylor County Clerk, Mr. Jaron Freeman, and from the County Clerk's office, Mr. Rob Gallo. If you all would please make them feel welcome. Thank you.
Gentleman from the 13th.
Thank you, Mr. Speaker. In the West Gallery today, we have Wood County's Clerk, Joe Gonzalez. If he'd please stand, and everybody make him feel welcome.
Gentleman from the 80th.
Thank you, Mr. Speaker. Ladies and gentlemen, with us today in the West Gallery from the heart of Morgantown and Suncrest, we have Beverly Kerr, who's here with the AARP today. If she could stand up, the House, give her a warm welcome.
Gentlelady from the 56th.
Thank you, Mr. Speaker. Good morning, everyone. I've got 2 pages with me that I'm excited to introduce if they would stand, if they're not running around already. We've got Kara Reynolds. She is homeschooled. It's her first year being homeschooled, and she loves it. Yay. And we've also got Alyssa Stover from Nicholas County High School who wants to study foreign relations. If everyone would make them both feel welcome.
Finally, the acting chair would be remiss if I did not introduce my guests. Scattered throughout the viewing galleries, I have about 30 students from Nitro High School, along with the long-term sub who's taking my position while I am here. She was actually my 11th grade history teacher at Nitro. If they would stand and the House could make them feel welcome.
Are there other introductions? If not, standing committee reports.
Your Committee on the Judiciary has had under consideration House Bill 4098 to restore the right of a person to sit on a jury has been restored upon expungement of one's record and reports to committee substitute back therefore with recommendation committee substitute do pass.
Report will be received.
Your Committee on Health and Human Resources has had under consideration House Bill 4602 relating to requiring the Department of Human Services to establish a pilot program to contract for supplemental casework aid services for the Bureau for Social Services and report the same back with recommendation that the bill do pass.
Report to be received.
Your Committee on Government Organization has had under consideration House Bill 4463 relating to the Board of Sanitarians and House Bill 4784 extending the qualified opportunity zones until July 1, 2032. Reports committee substitutes back therefore with recommendation each do pass.
Report will be received.
Your Committee on Government Organization has had under consideration House Bill 4462 prohibition on cell-cultured products and House Bill 4561, clarifying the sheriff's authority to hire within their office. Report same back with recommendation each do pass.
Report will be received. We have other standing committee reports. If not, select committee reports, executive messages, Senate messages.
Clerk of the Senate announces that the Senate has passed the following bills. Committee substitute for Senate Bill 440, increasing penalty for transporting telecommunication devices into jails.
Message to be received. The bill will be referred to the Committee on Judiciary.
Committee substitute for Senate Bill 592, West Virginia Short Line Railroad Modernization Act.
The message to be received and the bill will be referred to the Committee on Finance.
Committee substitute for Senate Bill 607, relating to federally approved project delivery methods for airport capital improvement projects.
The message to be received and the bill will be referred to the Committee on Government Organization.
Committee substitute for Senate Bill 615, requiring persons with illegal immigration status be turned over to ICE.
Message to be received and the bill will be referred to the Committee on Judiciary.
Committee substitute for Senate Bill 625, relating to responsibility of Board of Public Service District that is being dissolved.
Message to be received and the bill will be referred to the Committee on Energy and Public Works. We have other Senate messages. If not, resolutions.
House Resolution 13, proposing approval of the United States House Resolution 5966, Ohio River Restoration Program Act.
Gentleman from the first.
Thank you, Mr. Speaker. I ask unanimous consent that the third reading of resolutions introduced be dispensed with, and that each resolution be considered as having been formally introduced and referred to the appropriate committees as indicated on the Chamber Automation System.
The gentleman from the first asked unanimous consent that the further reading of resolutions introduced be dispensed with, now that each resolution be considered as having been formally introduced and referred to the appropriate committees as indicated on the Chamber Automation System. Are there objections? No objections are heard. Petitions. Bills introduced.
House Bill 5386, relating to candidate certificate of announcement.
Gentleman from the first.
Thank you, Mr. Speaker. Unanimous consent that the third reading of bills introduced be dispensed with, and each bill be considered as having been formally introduced and referred to the appropriate committees as indicated on the Chamber Automation System.
Gentleman from the first asked unanimous consent for the reading of bills introduced be dispensed with, and that each bill be considered as having been formally introduced and referred to the appropriate committees as indicated on the Chamber Automation System. Are there objections? No objections are heard. Motions. Unfinished business. Bills on third reading.
Committee substitute for House Bill 4011, relating to advanced recycling.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. Gentleman from the second, Douglas Teslo, is recognized to explain the bill.
Thank you, Mr. Speaker. To my colleagues, if you remember several years ago, we passed the Advanced Recycling Bill, which changed the solid waste code to allow for special recycling of organic materials, particularly plastics. Now, this bill amends the Solid Waste Management Act, and the reason for it is to implement the certification of recycled materials in new products by third parties. In other words, an independent third party will determine what the ratio of recycled products are. The system will make it possible to track the ratio between recycled and raw materials and products. Companies will be able to make credible claims about recycled materials in advertising and other purposes. The bill defines new technical terms and directs the DEP to begin to select third-party certification systems and pass rules. Once the system is fully implemented, manufacturers will be able to track and make credible claims about the amounts of recycled materials in their products. This will encourage recycling and better inform the public. Mr. Speaker, I urge passage.
You've heard the bill explained. The question before the House is, shall the bill pass? Is there debate on the bill? If not, those in favor of passage of the bill will please vote aye. Those opposed will please vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will please close the machine and ascertain the result on this question. We had 96 ayes, 0 nays, and 3 members absent. A majority of the members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4011.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4053 to establish the Blue Envelope Program.
Question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. The gentleman from the 58th, Douglas Hall, is recognized to explain the bill.
Thank you, Mr. Speaker. The Blue Envelope Program is a voluntary, self-implemented initiative designed to improve and de-escalate interaction between law enforcement and community members with disabilities or conditions that may affect communication, such as autism spectrum disorder, anxiety, or dementia. When presented during a traffic stop or other police encounter, the Blue Envelope provides officers with critical information to help them adjust their approach and ensure a safer, more respectful interaction. The Blue Envelope will consist of important documents such as a copy of their driver's license, vehicle registration, proof of insurance, and an emergency contact card. Thank you for the opportunity. I urge passage.
The question before the House is, shall the bill pass? Is there debate on the bill? If not, those in favor of passage of the bill will please vote aye. Those opposed will please vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will please close the machine and ascertain the result on this question. We had 96 ayes, 0 nays, and 3 members absent. A majority of members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4053.
Are there title amendments? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4179 to create felony charge for individuals who assault police officers or police dogs.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. Gentleman from the 75th, Douglas Mallow, to explain the bill.
Thank you, Mr. Speaker. House Bill 4179 will create a felony charge for individuals who assault police officers or police dogs. Colleagues, day in and day out, we ask them to address dangerous situations on our behalf and to protect and our loved ones. In turn, we need to help protect them. Give them the honor and respect they deserve. That's a summarization of the bill, and I urge passage.
The question before the House is, shall the bill pass? Is there debate on the bill? Gentleman from the 57, Douglas Lewis, is recognized.
Thank you, Mr. Speaker. The gentleman yield for a question.
Certainly.
So in addition to, you mentioned law enforcement officers would be protected by this bill. It also includes like government representatives, correct?
Yes.
Would we qualify as government representatives? All right. And specifically as it relates to battery, does there have to be like a malicious nature to the battery, or is it just any unconsenting touching that would
I think it's an attack on a law enforcement officer. Anyone trying to correct the situation and they're attacked, I think they'd fall into this category.
Does it specifically outline that in the bill? Because it just says battery, and battery could just be a...
Say that again, please.
When you say attack, it doesn't specifically outline that in the bill. It just says battery. Battery could be...
An assault upon. An assault upon a law enforcement officer or anyone trying to go in an official capacity to correct the situation.
Okay. I'm just looking at Section D, so it'd be line 36 on page 3 of the bill. That section, it says, when it discusses a battery is just, it can be an unconsenting touch and not necessarily, or an offensive touch and not necessarily an attack. So if you're, getting into it with constituent and you get poked, then that would constitute a battery, right?
Be the traditional definition of battery. Okay. Non-consensual touching.
Got you. So we're elevating the battery in this sense from a misdemeanor to a felony based on the person's status and their job occupation,
Yes.
correct? Okay. Thank you.
Gentleman from the 25th, Douglas Hornbuckle, is recognized on the bill.
Thank you, Mr. Speaker. Would the gentleman yield?
Certainly.
Thank you, sir. To piggyback off the delegate from Kanawha's line of questioning, is there any evidence or data that supports the elevation of this to a felony?
From my personal experience, we've had several in the north I just had, right before we came down for session, I had a police officer attacked. And I just don't want it to escalate to where someone that's coming there on our behalf ends up being injured or worse.
Okay. Is there any clear safeguards in this piece of legislation to prevent any type of overcharging or misuse of the language in regards to people committing this?
I think it's prosecutorial discretion. It's generally used to prosecute, and it's up to their discretion.
Okay, so no.
Pardon me?
So no? There isn't any clear safeguards?
There's nothing structurally within the bill, no, but it would be up to the discretion of the judge.
Okay. And what are the fiscal implications of this bill in regards to court proceedings, prosecution, incarceration cost?
There's nothing in there now, but in terms of more and more people being charged with this, there could be some additional cost.
But we don't know what that fiscal note is, correct?
No, it would depend upon the number of infractions, obviously. We're hoping that this will keep it from happening altogether.
All right. Thank you, sir.
Thank you.
Is there further debate on the bill? If not, gentlemen, the 75th to close debate on the bill. Chairman declines to close debate on the bill. The question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will please close the machine and ascertain the result on that question. There are 94 ayes, 2 nays, and 3 members absent. A majority of the members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4179.
Are there title amendments?
Delegate Akers moves to amend the title.
The question is on adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares the title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Gentleman the first.
Thank you, Mr. Speaker. Unanimous consent to move committee substitute for House Bill 419A to the foot of bills on third reading.
Are there objections? No objections are heard. The calendar will be so ordered. Further bills on third reading.
Committee substitute for House Bill 4345 relating to the preservation of missing persons records and evidence.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. Gentleman the 55th, Delegate Akers, to explain the bill.
Thank you, Mr. Speaker. This bill, House Bill 4345, creates a requirement for permanent retention of records in unresolved missing persons cases by the relevant law enforcement agencies. It clarifies that the documentary evidence must be digitized and that all physical and biological evidence must be stored according to current policy. The documentary evidence that is digitized shall be transmitted to the West Virginia Fusion Center for inclusion in its cold case database. And the bill further requires the Fusion Center to maintain the records until notified that the person has been located or the case or complaint has been resolved. That's an explanation of the bill, Mr. Speaker. I urge passage.
Question before the House is, shall the bill pass? Is there debate on the bill? Is there debate on the bill? If not, those in favor of the passage of the bill will please vote aye. Those opposed will please vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will please close the machine and ascertain the result on this question. We had 95 ayes, 0 nays, and 4 members absent. A majority of the members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4345.
Are there title amendments? If not, the title is read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Next bill on third reading.
Committee substitute for House Bill 4468 relating to confidentiality of court files and law enforcement records.
Question before the House, shall the bill pass? Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. Gentleman the 55th is recognized to explain the bill.
Thank you, Mr. Speaker. House Bill 4468 amends existing code, clarifies and ensures that the name and address of victims in certain crimes, most especially those involving certain sexual offenses, shall remain confidential if information regarding their court file is disclosed. Provides certain exceptions for waiver by the victim if they so choose, along with disclosure to other appropriate governmental entities or agencies. and also repeals unnecessary provisions of the existing code relating to court orders or for release of confidential records. It just provides further clarification that's consistent with updates and internal effective dates. Mr. Speaker, that's a brief explanation of the bill. I urge passage.
The question before the House is, shall the bill pass? Is there debate on the bill? If not, those in favor of passage of the bill will please vote aye. Those opposed to please vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will please close the machine and ascertain the result on this question. There were 95 ayes, 0 nays, and 4 members absent. A majority of members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4468.
Are there title amendments? If not, the title is read, but the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate for the bills on third reading.
Committee substitute for House Bill 4600, require all ballots for primary and general elections be received not later than the close of the polls on Election Day.
The question before the House is, shall the bill pass? With objections having the bill explained in lieu of having the bill read. No objections are heard. Gentleman from the 55th to explain the bill.
Thank you, Mr. Speaker. We had a great deal of discussion on this bill yesterday. I think we all know what it does, and the short title itself describes that absentee ballots, if this bill were to pass and become law, must be received by Election Day no later than 8 p.m. on Election Day rather than postmarked and then received by canvass, which is existing law. That's an explanation of the bill, Mr. Speaker. I urge passage.
Is there debate on the bill? Gentleman from the 5th, Doug Fluharty, is recognized on the bill.
Gentleman, yield.
Yes, sir.
I have a question on how we had an amendment yesterday dealing with overseas military.
Yes, sir.
And it was shot down. I have a question how federal law now this will contradict, in particular the Uniformed Overseas Citizens Absentee Voter Act. And we touched on this in committee, but under 52 USC 20302, there are state requirements. And those state requirements state that receipt of the ballot is by election, that receipt of the ballot as long as they vote by Election Day. And we are arbitrarily saying that it must be received. So they go by when the vote is cast, not when the ballot is received. If we are now contradicting federal law, how will that play out?
Yeah, well, so number one, I don't think the deadline we've set is arbitrary. It's actually consistent with existing federal law for federal elections. So by example, 2 U.S. Code Section 7 sets a time for federal elections as Election Day. There's actually currently federal litigation pending on that matter right now. So this would actually be consistent with what the interpretation that the Fifth Circuit Court of Appeals has determined so far on that. Now, with regard to whether a UCAVA ballot must be received by Election Day or that it must simply be postmarked, if UCAVA conflicts with state code, UCAVA would preempt state law in that circumstance.
Correct.
So if it's a UCAVA ballot and it would be determined that it can be received or has to be only postmarked by Election Day, then UCAVA would preempt this code section if it becomes law.
So under UCAVA, we're required to count the vote if it is received, if it is postmarked before Election Day. We're required under law. So how are we going to carve out the military if you're correct, and I believe you are, that it would preempt? How are we going to do that administratively in West Virginia?
The same way they do it now. I mean, they count votes now that come in after Election Day as long as they're postmarked by Election Day. So that simply just wouldn't change for UCAVA ballots. I don't consider it to be difficult or a burden at all.
But there's no exception for the military in this legislation now. We shot that down.
But UCAVA could still apply to the military ballots, so that should not be an issue. And again, we've talked about this before. There are 21 other states that require ballots, absentee ballots, by Election Day, not postmarked, but by Election Day, which is a firm deadline. So to the extent those other states have that same requirement, if they for some reason have a conflict with UCAVA, then the military ballots will still be counted as long as they comply with the UCAVA requirements. So this will not change any of that.
I appreciate you yielding.
Yes, sir.
Very briefly, Mr. Speaker. Look, guys, there was a time when we actually cared about the Constitution down here. Federal law does not require receipt by Election Day. It requires the ability to vote by Election Day, specifically for our military. We are contradicting that. This will be challenged probably 10 minutes after it passes, and it will not stand. And it makes no sense. No evidence has been provided this is necessary. Nobody came to testify. It's just an arbitrary, nonsensical conspiracy theory government that we run here. We govern by conspiracy theories in the fringe. We're not talking about fraudsters. We're not talking about schemers. We're talking about our neighbors. In particular, whom are we talking about? The elderly, the disabled, and our military. Those are the individuals who request absentee ballots. And we are telling them that even though you made a good faith effort as a West Virginian, a good faith effort to make sure that you participate in our democracy, that you cast your ballot, that you had it postmarked, and that we, the government, because the mail system does not run properly, we are no longer going to count your participation in our democracy. It goes against everything we're supposed to stand for as Americans, and in particular, as West Virginians. I cannot support that. I will not support that. And I will not govern by conspiracy theories. Thank you, Mr. Speaker.
Gentleman from the 7th, Douglas Sheedy's recognized.
Thank you, Mr. Speaker. As a former military member that has been deployed overseas, I can state specifically that months before time, all I needed was to take a copy of my orders to the county clerk, and I would get on a list to be mailed an absentee ballot. I was mailed that absentee ballot. I filled it out the same day and sent it back in the outgoing mail from my forward operating base. Those absentee ballots do not require postage, therefore they do not require a postmark either. However, when they hit the APO office in New York, they are automatically redirected to first class mail and receive utmost priority. Thank you, Mr. Speaker.
Gentleman from the 54th, Douglas Pushkin, is recognized on the bill.
Yes, thank you, Mr. Speaker. Would the lead sponsor yield?
I do.
Gentleman does yield.
Thank you. And thanks for bringing this bill before us here. What is the issue that we're trying to correct here? What's the problem, the ongoing problem we've had in recent elections that would prompt you to introduce this bill?
Well, the issue what we're trying to correct, like 21 other states, is to have a definitive deadline like now, but make it election day. And that was driven in part by the December announcement by the U.S. Post Office that the date that you provide them mail doesn't necessarily reflect the date that has been affixed to it as a postmark. Now, are there ways around that such that you can have it hand stamped, et cetera, on and on and on? This announcement by the Post Office in December, in fact, was reiterated and sent out last month by our own Secretary of State, who I believe is still in the South Gallery. Oh, he's left.
Lost interest.
He sent out a notice to remind people when filing for candidacy and absentee balloting, et cetera, that the postmark's not something to be relied upon. Recent research has also discovered that, and the Secretary of State's office has confirmed, that metered mail is counted as a postmark, and it is possible to fiddle with metered mail. So this would fiddle, change the date to prior to the date that you actually mailed something. So this would definitely make it a very clear cutoff, and I know we're all in favor of election integrity.
Okay. I think a lot of us just want to make sure every legal vote is counted.
I can't hear you.
Okay. How would one change a postmark?
Well, I'm not a hacker, but if you Google it, I'm sure they'll tell you that it can be done.
Okay, because are you aware of any of this happening at all in West Virginia?
Have you checked every ballot, every postmark? I mean, you sound confident there.
Well, I've not. Nobody's been prosecuted for it, for tampering with, I think there are 5 cases. Since 2012, I did look it up, there have been 5 cases. Would that surprise you? There have been 5 cases of fraudulent absentee ballots since 2012.
I'm not surprised, I don't dispute it, but that's not the point of the bill.
Okay. Do you know of any cases in which the winners were announced on election night, And then after the absentee ballots came in, that changed.
Would you repeat the question, please?
Do you know of any instances in modern history, in recent history, let's say, in West Virginia, okay? The winners were announced on election night, and then after the canvass and after the absentee ballots were counted, the outcome changed.
I can't definitively state that. That'd be a better question for the Secretary of State's office.
Okay, well, so about maybe in your personal, one of your races, okay? You first were elected in 22, is that correct?
That's correct.
Okay, and how much did you win on election night? How much were you ahead by?
One vote.
In your primary?
One vote.
One vote. After the canvass, how much were you ahead by?
There were 3 additional votes in my favor, a total of 4.
So you picked up 3 votes in the canvass?
Correct.
Okay. So this could have cost you a couple of votes had this been in
Probably not. Those were provisional ballots.
Okay, well, thank you very much for yielding, sir.
Thank you.
Would the chairman of judiciary please yield?
Yes, sir.
Okay. During the deliberation process in your committee, were you able to determine if, let's say, if this law was in place last cycle in 24, and let's say it actually didn't change anybody's behavior, people still voted the same way they were, do we know how many ballots would have been thrown out had this been in place in 24?
I have no idea.
Did you bring any county clerks in front of your committee?
I mean, the county clerks were aware of this bill. I believe some did provide some input to the committee electronically or through personal conversations.
I can't hear you.
They certainly did. I mean, they knew this bill was in committee process, and we did have testimony from the Secretary of State's office, and some of the changes to this bill were at the request of the Secretary of State.
The absentee ballots.
Who is the chief elections officer?
Yeah, the absentee ballots go to the county clerks, correct?
That's correct.
So they would be able to answer the question of how many come in after Election Day, how many this would actually affect. But no county clerks testified during the committee process.
They were provided with notice. They certainly knew about the bill, and they didn't express any of the information or provide that information to us. So I can't tell you what numbers those would have been.
So none. They answered none testified in front of your committee, right?
The answer is none that they didn't testify, or the answer is none that no ballots were thrown out after canvass.
But we don't know because they didn't testify. Thank you for yielding.
Yes, sir.
Thank you, Mr. Speaker. I'm not exactly. I'm just trying to figure out what problem we're trying to remedy here. I can think of absolutely, and I've been following elections for quite some time. I don't know of any case in West Virginia where there was an announcement of a winner on election night, and then all of a sudden the absentee ballots came in after the fact and changed the outcome. I think what we always try to do is err on the side of counting the votes. I said it yesterday. If we want to talk about personal responsibility, well, the only thing that's within one's own ability to make to change is when they actually mail it. We have no control, unfortunately, of when it actually arrives. So it only makes sense that it's based on the postmark and not on the arrival date. That is beyond the voter's control, right? If somebody follows the rules, they get it in in a reasonable time, and then something goes wrong at the post office, they should not be punished by having their vote thrown out and have their right to vote taken away because of something that was beyond their control. I think if the intent of this legislation is to change people's behavior, which I hate to tell you this, what we do down here rarely does. People pay a lot less attention to us than we might think they do. But if the intent is to change people's behavior and get them to vote earlier if they're voting absentee, well, I would suggest extending the early voting period and possibly moving the postmark date. That's something that is within one's control, not the arrival of the ballot. I'm not sure what the problem is that we're trying to address here. It is creating more problems than what you're going to do. And we have no idea how many, but if this passes, in the next election, honest voters are going to have their votes disqualified because of somebody basing a piece of legislation on conspiracy theory, because they're still listening to somebody who's been making false claims about a stolen election 6 years ago. That's what this is based on, and it's ridiculous.
Gentleman from the 69th, Douglas Marple is recognized on the bill.
Thank you, Mr. Chairman. I rise to speak in opposition to this bill. I believe that it is an affront to the voters of West Virginia. Run newspaper ads on Sunday, radio ads on Monday to reach the voters. It's a waste of money if we're going to we don't have to run those ads if they're only going to count the votes that are made at the polls. A lot of elderly people aren't able to get to the polls. A lot of them don't make up their minds until they hear both sides, hear from the candidates that are running. And if we're going to eliminate this, that they can't vote and go by the postmark, right now votes are counted up till the time that the county clerks conduct the canvass. This is anywhere from 4 to 6 days after the election. On election night, they announce the result, but they know that the mail-in ballots still haven't been counted, and some of them haven't even been received yet. I think that we're doing an injustice to the citizens and the voters of West Virginia if they mail their ballot on Monday, get it postmarked at the post office, which you can do. They'll do it by hand. And they find out that their vote is not counted because they didn't receive it by the closing of the polls on election night. I've been voting longer probably than anybody in this room. I'm the oldest delegate here. I turned 82 last month. I voted from the time that I was 21. This was before they lowered the voting rate to 18. I urge that you vote this bill down. You preserve the dignity of the elections in West Virginia, and you allow people who mail their ballots on the day before election and have it postmarked. They'll never know it wasn't counted because nobody's going to notify them. Sorry, your vote came in too late. We didn't count it. Defeat this bill. Preserve the integrity of our elections, that every vote gets counted. Thank you.
Gentleman from the 100th, Douglas Ridenhour is recognized on the bill.
Will the sponsor yield?
Sponsor yields.
In your experience in my sister service of the Navy, do armed forces members generally follow orders?
That's why they call them orders, not requests. So, yes.
Understand. I believe that would be the case for most of the veterans in this body and on the other side of the aisle over in the Senate. And you generally find that units will, in fact, provide notice of upcoming elections. There's actually a voting officer in most units, correct?
It's funny you should ask that question. As a young naval officer nearly a half a century ago on the USS Spadefish, one of my jobs, some of you might have heard this before, especially our listening audience. In addition to being welcome aboard, I was assigned the SLJO position, Little Jobs Officer is the last 3 words. One of those included, you are the voting officer. My role is to make sure everybody casts their ballot as soon as possible.
And in the Navy, they have Master Chief Petty Officers, correct?
That's correct.
And those generally will tend to ensure that the sailors in that boat or, ship, yeah, whatever, will in fact be informed of essentially every requirement that they need to have. And that would include putting in a ballot in time.
I think
to request and put in a ballot, correct?
Yes, you are correct. I believe most junior enlisted probably are more afraid of their Master Chief Petty Officer than some junior officers.
So they'll tend to follow those orders and actually comply with what the Master Chief is letting them know.
Yes, sir.
Thank you. Permission to speak to the bill.
Gentleman's recognized.
Okay. I was in the Marine Corps for 20 years. I voted every opportunity that I had. It was made clear to me that I needed to vote. I made it clear to my troops. We have what we call not Master Chief Petty Officers, but First Sergeants. Our First Sergeants are known to be pretty forthright. They are pretty direct. They don't mince words. They will go out and they will instruct our troops as to what they need to do. One of the things that they need to do to preserve our republic is to vote, to ensure that they're participating in our republic and in the elections that define our republic. I, frankly, was in the stinking mud of South Korea up near the DMZ. And I call it stinking mud because if anybody knows what night soil is, you'll understand why. It was freezing. We got our ballots after we had deployed. I filled out my ballot. I put in free. Free is how you get mail sent when it's personal mail. So as far as I know, it made it back. And I was able to cast my vote for the great Ronald Reagan. I don't have any real doubt about how we are voting in the armed services. If we want to vote, it is not that hard. We make decisions relatively rapidly. In this case now, as a major advance over the way that I had to deal with it, and I'm sure as over some of the other veterans in this body have to deal with, we have electronic voting. It is far easier. I could have had electronic voting in South Korea. Would not have been hard at all. You just simply get you find out what the candidates want to say, you go to a machine, you type it in. It's not that difficult. This is very easy, and that's how I think this is going to get done. Thank you, Mr. Speaker.
Gentleman, the 22nd, Doug Linville is recognized on the bill.
Thank you, Mr. Speaker. So there's been a lot of discussion and debate today on this bill surrounding, what problem that we're trying to solve. And I appreciate the gentleman from Kanawha bringing up instances of fraud since 2012, because in 2010, in Lincoln County, West Virginia, they stuffed the ballot box with absentee ballots. So actually, the minority leader and I formerly represented part of Lincoln County. And you can Google this. You can find it. It came straight from the West Virginia Gazette Mail. I'm going to read it to you. Ramey had conspired with Lincoln County Sheriff Jerry Bowman and Clerk Donald Witten to flood their party's primary with absentee ballots, the filing said. Witten was campaigning for another term in the Democrat-dominated county where the party's primary winners typically prevail the following November. Unable to run for sheriff again this year because of term limits, Bowman was running for circuit clerk in 2010, while Ramey had been appointed commissioner and sought election to keep that seat. They submitted false filings for absentee ballots. They covered it up. And something that's key with this bill is this. If you know on election night, or you have a pretty good idea of the totals, you can stuff the ballot box with additional absentee ballots that you falsified, right? And then all of a sudden you know the number that you need. 300 absentee ballots in Lincoln County were thrown out that year. All because of this. So you want to talk about postmarks and when things need to be postmarked by, right? With a Pitney Bowes machine, you can actually change the date, right, that you're postmarking something. So if you do bulk mail out of somewhere, you actually get to place the postmark on it yourself, right? So it's important that these are received by Election Day, not just postmarked, right? Because you can alter a postmark. It's got an internal clock in it, and if you don't connect it to the internet, it's not necessarily continuing to reach out and figure out for sure what day and time it is. You guys might have seen your computers do this before, right, and have an incorrect day and time. So this bill is solving something. And I'll perhaps leave it with this. This is a quote from U.S. Attorney Booth Goodwin. "The citizen's vote is the very foundation of our democracy. When that vote is bought or sold or obtained by fraud, democracy itself is in peril." United States Attorney Booth Goodwin. I agree with him. Mr. Speaker, I urge passage.
From the 80th, Eggert Williams is recognized on the bill.
Thank you, Mr. Speaker. Would the chairman of Judiciary yield for a quick question?
Just one?
Maybe a follow-up, if you'll allow it.
All right.
So I just want to make sure that I understand the process because I've never voted absentee before. So I request my ballot, I get it, and then I send it to the courthouse. Is that right?
goes back to the county clerk's office.
So it goes to the county clerk's office, and then under this bill,
Well, let me correct you. That's the way you would do it here in West Virginia, or if you were out of state as a paper ballot. You can vote electronically, like in certain circumstances, like with UCAVA, but just for you personally, your example probably is yes, you would fill out a paper ballot and mail it back into the county clerk.
okay, so at the county clerk's office at the courthouse, and under this bill, any ballot that comes in until 7:30 or 8 p.m. is good?
It's 8 p.m.,
8 p.m.?
which is when polls close.
Okay. Are courthouses generally open or closed on Election Day?
The courthouses will be, the courthouse is always open. I'm not sure if they would actually receive mail on Election Day. I believe that they would. Think about that.
So you're not sure if the courthouses will even receive mail?
Well, the courthouse, the courthouses are never fully closed. There's always personnel there unless there's some sort of, disaster or weather event that prevents people from getting there. But I'm trying to recall if they would actually receive mail on Election Day. I'll look to council for that question. Yeah, I don't know if the post office, I don't know if they would deliver mail that day or not, to be honest with you.
Yeah.
Yeah, if you have, if it's a state, county, or local election, obviously that won't affect the Postal Service. On the federal election side, I think that they would, that may be different. I apologize, I can't answer that question for you. On the federal side.
That's okay. So under the assumption, which I think maybe we've both come to, we don't know if mail is delivered. I'm leaning myself towards it's not delivered on Election Day. Is it safe to say that this new deadline that's been established is actually 24 hours in advance, the Monday preceding Election Day? Is that the true deadline by when this ballot's got to come in?
If the Postal Service would not deliver on a federal election day, if that were true, and I'm not saying whether they would or they wouldn't, apologize, I can't tell you that, then you would have to have your ballot in the day before. But again, for a state local election, then they would still deliver on Election Day.
And for the state and local election, the feds, the USPS might deliver on Election Day, but maybe in my county, the county clerk, we have an election central. Nobody's at the courthouse to go get mail. So that could also be problematic to get those ballots in, right?
Well, first of all, I would say I would almost guarantee, I can't promise you what your county clerk would do, but I bet you would still have the mail delivered from the county courthouse to the election center because people will still be there to receive mail on Election Day. Council did tell me that the the U.S. Postal Service will deliver mail on Election Day. That's information he looked up while I personally couldn't answer your question, which again, I apologize for. But, so with that being said, if council's information is correct, that the mail and ballots should be delivered on Election Day, federal, state, or local, and if the mail is delivered to the county courthouse, your county clerk could arrange to have it delivered from the courthouse to the election center.
I appreciate that. Are we requiring the county clerks to have that system in place, or could a random county clerk just say, oh, to hell with it, I don't feel like setting up the system to have our mail brought over here?
A random bad county clerk could do that if it wanted. I have a hard time believing that any of them would. I kind of trust our county clerks, but in the realm of anything's possible, they could not do their job, sure.
Okay. Thank you so much for yielding. And I, too, do trust our county clerks, which is why I don't know that this bill is really necessary. I had a close one time back in 2020. I had a close election. That was the big year where COVID absentees were being submitted. I think election night ended in a 5-member district. I was up by 29 votes. And I went to the canvass. I saw the hard work that our poll workers put in, counting those votes, that our clerks put in, organizing that. And after what had been a really nerve-wracking 6 or 7 days, they finally they think everything ready to go. They're going to announce what's happening. From my own selfish standpoint, I'm trying to figure out if I'll come back down here or if I'll have the chance to spend more time with my family. And then they say, wait a minute, the courthouse just called. We have more ballots that just got delivered by mail. I should have been upset about that. But at the end of the day, like every single one of you in this room, it was beaten into my brain. So now that I know it in my heart, that we count every vote in this country. That's the bedrock of this thing. That's important. And when you're talking about the military side of things, that they follow orders, I agree they follow orders. That's great, 100%. But now they're going to have to get their ballots in even earlier. People are going to be operating under a different set of facts many times in our elections with October surprises. There was that thing a few years ago with the whole bus with Billy Bush, the whole thing, you know, what happened there late in that election. I don't think that this is the way that we go about instilling confidence in our elections. You see dubious claims being made at the highest levels of government about our elections, and guess what? Words do matter. When we talk about random, you know, this could happen, that could happen, cases of fraud that did occur, well, guess what? We found out about the fraud. We're doing a pretty good job of picking that stuff up. This isn't the way to do it. This isn't the way to treat our people who voted us in to say, hey, better have your homework in on time or else you're not going to have your vote counted. I urge rejection.
Gentleman from the 53rd, Doug Levitt's recognized on the bill.
Thank you, Mr. Speaker. Would the gentleman from the 5th yield?
Sure.
Thank you. So I've just been searching and searching and searching, trying to understand something you were talking about earlier. You referenced UOCAVA, the Uniform Overseas Citizens Absentee Voting Act. Can you reiterate what you were saying earlier about the deadlines in statute?
Yeah, 52 U.S. Code 20302 lays out the state responsibilities. And among those state responsibilities is that federal law does not require receipt by Election Day. It requires the vote to be cast by Election Day.
And which provision of...
I believe it was subsection E.
Okay, so subsection E there.
That's between UCOVA and then the MOVE Act also. It's federal law.
So sorry, where in subsection E?
Subsection E is designation of means of electronic communication for absent uniformed service voters, and within that, the designation to the state under the federal law is that states have certain parameters they have to follow. Among those parameters, that through forever, is that Election Day is what counts. It's not an arbitrary number.
I'm looking at section E. I see electronic communication. Where are you pointing to, saying that Election Day is the postmark by Election Day is the deadline?
With that in the MOVE Act, it's always been Election Day. Can you point to any example where it's not Election Day?
Well,
in any state?
Actually.
Federally?
In the state of Delaware, where our former President Joe Biden was from, yes, they have the deadline of being received by the close of polling on Election Day. In the state of Vermont, where Bernie Sanders is from, they have
And they have carve-outs for military personnel.
No, this is for military.
I believe they do. We don't.
The National Conference of State Legislatures has a lovely graphic. I will send it to you. It illustrates the 21 states in our nation that have the deadlines of being received by the close of polling on Election Day. The other 29 have postmarked or sent by Election Day.
You know what those states also have? Drop boxes. Do we?
Okay. Well, again, just to home back in. So, where in the MOVE Act will you point me to that citation?
I don't have the MOVE Act up. You could probably have come up to judiciary and gone through the questioning.
The chair will permit questions, not colloquy. Does the gentleman have other questions?
Yeah, sorry. Is there a place in the MOVE Act? Is there anywhere in federal code that you can point to?
I don't have it in front of me, no.
Okay. Thank you for
prepare the
yielding
MOVE
the time.
Act for you.
I appreciate you yielding the time. Mr. Speaker, I have looked through. I've not found anywhere in code where it indicates that there's any preemption by federal law or anything else. There are 21 other states that do this. I understand there are policy disagreements that people may not like this as a deadline. And I understand that whatever we do, we want to educate our people about. But I do think it's a little disingenuous to claim that we are disregarding votes or that we are trying to disenfranchise anybody. This is something that is done in almost half of the states in the nation, including by very liberal states, and it has never posed an issue. Would the gentleman, the chairman of Judiciary, yield?
Yes, sir.
Do you have familiarity with the electronic voting requirements that are in fact prescribed when you read 52 USC 2302 in terms of UOCAVA, what happens, how military members vote electronically?
Yeah, they vote through a secure portal provided by the Secretary of State's office here in West Virginia, which I believe in the 2020 general election, I promise you, but I'm about 98% sure that all of the UCAVA votes in West Virginia were electronic. And that service is provided free of charge to service members through the Secretary of State's website.
So
And
because
then we actually have some electronic ballot access as well for disabled. Some discussion's been about disabled voters. We also have some of that available to disabled voters in the state of West Virginia as well.
Thank you. So because of the federal requirements that we comply with under UOCAVA, we have an electronic voting system. Military members are able to use from anywhere in the world overseas. In the last voting cycle, there were no paper ballots that were mailed here, whether postmarked by Election Day or otherwise.
Well, the most recent information I could find before speaking was 2020. I'm not sure about 2024 federally. That was 2020. They were all electronic ballots that were cast. There are some states that still require a paper ballot for UCAVA. West Virginia is not one. We're actually one of the leading states on electronic voting in that regard and some other contexts. So we do allow that for our service members. So that's something we should be proud of.
Thank you.
Yes, sir.
Well, Mr. Speaker, I would encourage everybody, if you are uncertain about this, to go and Google NCSL Table 11 Receipt and Postmark Deadlines for Absentee Mail Ballots, which highlights the 21 states that have already done this. Thank you very much.
Gentleman from the 25th, Douglas Hornbuckle, is recognized on the bill.
Thank you, Mr. Speaker. Very quickly, would my friend from the 22nd yield for a quick question?
Yes.
Yes, sir. You laid out that situation earlier that occurred, 15 years ago or something like that?
2010.
2010. Were those folks convicted?
They sure were.
All right, thank you.
They actually pled.
They were convicted.
I'm not sure that a plea is a conviction by a jury. They pled.
Yeah. Convicted. Thank you. Permission to speak to the bill?
Yes, Chairman is recognized.
First, under our current code, people will be held liable if they try to do anything that is an infraction upon the integrity of our election system. Those people were convicted. I believe in our judicial system and our current code. There is no issue here. I also find it very rich today that as we engage in civil discourse before we go to vote, we're not imposing a deadline on ourselves. But we're going to do it to our neighbors across the state. I find that very, very rich. And it's been said a few times of, what is the problem here? Is there a problem here? The problem is, for the past few years, we've had bill after bill after bill to restrict voting rights. That is the problem. We've heard from a couple people on this House floor today that hasn't really been brought up much is the challenges that we're bringing to our county clerks. Have we really thought about that? Have we thought about the challenges that are going to be brought to the election day workers? I, like some of you all in here, I had to do that before just to be able to get by, to work on election day a couple extra shekels. And any of my friends in here that have done that, you know that it's complete chaos. It's a lot of running around, and you've got to do all the things. There's no capacity to handle these things. And then going back to our neighbors, the disenfranchisement. I'm going to stand with Granny and Pawpaw today. The ones that, and some of us in here, through no fault of their own, they might have to go to that doctor's appointment to get a checkup, or even worse, they've got cancer, or they just became ill. And for no fault of their own, they couldn't meet that specific day. That they couldn't do that. West Virginia, the state that I love, it is very rural. It's very rural. Our systems are currently not efficient enough to help my good friends who might live in a holler, who might have issues, and they just need a day or two to be able to engage in the process of voting and civic engagement. It's going to affect the vast majority of West Virginians. And last but not least, we talk about our veterans and our military personnel. And we've gone back and forth about this, the folks that are overseas and what they're doing. But I just want you all to imagine. Close your eyes and imagine that we have military personnel that are going outside of their jurisdiction for unforeseen circumstances, and an issue arises. We don't have to imagine it. West Virginia National Guard, taken out of our state to go do something, and they're hurt, they're maimed, even killed. And they're sitting inside that hospital. And they don't have the opportunity to meet this deadline today that we're going to put on them. Those people that are fighting for us, we shouldn't tread on them. Oppose this bill. Thank you.
Gentleman from the 88th, Delegate Hillenbrand is recognized on the bill.
Thank you, Mr. Speaker. So today we've had an awful lot of folks pulling at our heartstrings talking about the military, many of whom never wore the uniform. Those that wore the uniform seem to think this isn't an issue. There's been a lot of statements made about UCAVA, kind of trying to cloud the issue. You can look this up just as well as I can. Federal requirements on UCAVA do not in itself lay out a specific postmark versus a receipt deadline for counting ballots. Instead, it sets broad procedural protections for uniformed service members and overseas voters, such as sending ballots early, at least 45 days before a federal election, and allowing registration, absentee ballot requests, and ballot submissions without certain state formalities. The Act specifically does not explicitly require the states count every ballot postmarked by Election Day and received later. Yesterday, I took the time to talk with Mr. Scott Weidman, the director of the Federal Voting Assistance Program at the U.S. Department of War. A lot of people ask questions, well, how does the military vote when they're doing this or that or whatever? And he spelled it all out for me. My notes read, first, the military are covered, as we've already talked about, since 1986 by UCAVA. Secondly, West Virginia military voters can absentee vote electronically. In the last 10 to 15 year time frame, Mr. Weidman was uncertain on this, something that was not available when I was a young naval officer. Mailed ballots have what's called an 11 DOD label affixed to them. 11 DOD label. Never heard of it before. The USPS guarantees, and we all know that probably should be in quotes, 7-day expedited delivery. However, in 2024, they achieved 5.8 days. In the context of absentee ballots, an 11 DOD label refers to a Department of Defense label 11, a special mailing label used in the military postal service. Here's what it means in plain English. DOD label 11 is an official military mailing label used to send mail from overseas military locations to the United States. It provides a stateside USPS entry point, often New York or San Francisco. Mr. Weidman told me primarily Chicago. So the mail can be carried through the military mail system and then injected into the USPS without normal international postage. Now, how it relates to an absentee ballot, when a service member or eligible overseas voter mails an absentee ballot from an AFPO or FPO or DPO address, the ballot may be placed in a pouch or envelope bearing a DOD label 11. This allows the ballot to travel postage-free under federal law. Once it reaches the USPS gateway in the U.S., the ballot's treated like domestic first-class mail, not international mail. And why this matters is it speeds delivery compared to commercial international mail. It ensures ballots are not rejected for insufficient postage, and it maintains chain of custody within the military mail system. It also helps comply with UCAVA. What it does not mean, it is not a ballot tracking number, it's not a voter identification, it does not indicate how someone voted, only how the mail was transported. Once the USPS mail system 11 DOD label mail is placed, once in the USPS mail system, the 11 DOD label mail is placed in the express mail and then proceeds like normal express mail, including delivery on Election Day. Knowing that paper ballots may enter the USPS mainstream any number of ways, base mail, Army Post Office, shipboard postal for large ships, fleet post offices, mail is all sent generally by air to Chicago, as I said before, where it's postmarked if it has not previously been postmarked, and then mailed express. You can ask to have the ballot hand canceled even if it doesn't require postage when it's placed in the military post office, even, I already said that. It is noteworthy to mention that on large ships like an aircraft carrier, they have their own postal service on board. Previously, the mail on a carrier was given to a postal clerk, a rated enlisted person, now called a logistics specialist, who has special postal qualifications to handle postal operations. Carriers frequently have daily mail delivery via the Carrier Onboard Delivery Aircraft, called the COD. Smaller vessels and submarines frequently hold their mail until they get to a port. And how that actually works, the mail's collected on board, the sailors address the mail to or from the FPO or APAA address. The vessel's designated postal clerk prepares and bags the mail. The mail is then transferred ashore, but not to local mail. When the vessel pulls into a foreign port, the mail is turned over to a U.S. Navy activity, a U.S. embassy or consulate, or a nearby fleet post office or military post office. The mail never enters the host nation's postal system. Mail error or secure transport then occurs. Outbound mail is flown via military aircraft or contracted DoD airlift, or secure diplomatic or military courier routes. Mail is containerized and documented under military postal service rules. DoD Label 11 is used to move the mail such that it goes through these designated USPS gateways. It allows it to travel postage-free outside of those international mail rules. Some vessels, submarines, mostly are deployed for long periods of time, more than 60 days without servicing. The process to vote is exactly the same. So the question becomes, what happens if the timing is tight? If there's concern a state ballot won't arrive on time, there is a federal write-in absentee ballot process. Sailors can vote using the federal write-in absentee ballot, a backup ballot allowed under federal law. This is very common for submarines and special operation units. And as I told you, when I was a young naval officer, that was one of my jobs, is to make sure people got those ballots and got them posted immediately. Thank you, Mr. Speaker. I urge passage.
Are there other members who wish to speak on passage of the bill? If not, does the gentleman of the 55th wish to close debate on the bill? The gentleman waives the right to close debate on the bill. The question before the House, shall the bill pass? Those in favor of passage of the bill will please vote aye. Those opposed will please vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will please close the machine and ascertain the result on that question. There were 79 ayes, 17 nays, 3 members absent. Majority of the members having voted in the affirmative, the chair declares that bill passed. The clerk will please report the title.
Committee substitute for House Bill 4600.
Are there title amendments? If not, the title as read by the clerk will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. For the bills on third reading.
House Bill 4749, relating to adding requirements to the Foster Child Bill of Rights.
This bill was advanced to third reading with an amendment pending. At this time, the clerk will please report the amendment.
Delegate Akers moves to amend the bill. This is HFA Akers 2-9 number 1.
Are there objections to having this amendment explained in lieu of having it read? There are no objections. Gentleman of the 55th is recognized to explain the amendment.
Thank you, Mr. Speaker. The substance of this amendment just ensures that a child in foster care placement who may at times be a distance from the courthouse has the option and ability to attend a hearing virtually if necessary, and if the court believes that's practicable in the child's best interest. That's the purpose of the amendment, Mr. Speaker. So the child may attend in person or if necessary to avoid delaying their case virtually at the court's discretion. There is preference in the amendment that if practical in the child's best interest, they will be given the right to attend in person if that's available. That's a brief description, Mr. Speaker. I urge passage.
You've heard the amendment explained. The question is on adoption of the amendment. Is there debate on the amendment? If not, those in favor of adoption of the amendment will please say aye. Those opposed will please say no. The ayes have it. The chair declares that amendment adopted. Are there other amendments to the bill? If not, the clerk will please read the bill a third time as amended.
House Bill 4749, relating to adding requirements to the Foster Child Bill of Rights.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having the bill read? There are no objections heard. Gentleman from the 23rd, Delegate Worrell, to explain the bill. Gentleman from the 55th, Delegate Akers, to explain the bill.
Thank you, Mr. Speaker. I'm just going to briefly explain how the bill got here from our committee. Then the gentleman from the 23rd is going to explain how he was primarily responsible for the drafting of the bill, along with his co-sponsor from the 92nd. They deserve primary credit for this bill being here today, along with Ms. Curry, who's upstairs, and I believe it was actually her 18th birthday yesterday. So she was involved in the drafting of this legislation when she was still 17 years old. She was here on a visit to the Capitol, which delegate from 23rd will get more into that here in a moment. But just briefly from the Judiciary Committee, Mr. Speaker, this bill was heard just a few days ago on first reading in our standing committee. This bill provides that foster children at the age of 13 and up will be given notice of court hearings that implicate their legal rights. Ms. Curry said it was important to her as a foster child to know what was going on in her case. Not that she thought that information wasn't being kept from her, but she wanted to know what was going on because it affected her life. She didn't have parents to advocate for her. She had to rely upon court personnel like the guardian ad litem and other CASA volunteers, potentially other folks like that. Of course, she has a good support network with her Daymark staff and other people like that, but she wanted to know what was happening in court. So she came up with the idea of saying that she should be told, other foster children should be told when they have hearings implicating their legal rights, and that they have the right to appear at those hearings. Even though those court hearings may sometimes be difficult, they want to know what's going on in their lives. We heard that on day one in hearing just a few days ago. The gentleman from, make sure I get his number right, the 93rd, after we heard the presentation of the bill, decided we'd heard enough and moved with unanimous consent to have the bill moved to markup and passage, which I thought was a great idea, by the way. I wish I thought of it myself. So we were able to pass the bill that day with Ms. Curry in the room with us. We did a roll call. And I'll tell you, on that day, she had a bunch of other foster children with her, some of her peers. And it was great. They were all lined up in the committee room. The young men were in sport coats and ties and suits and ties. The young women were dressed up like they were going to a job interview. They just looked professional and really nice. And, it just made you think to yourself, that's what every day should be like for you all. And we appreciated it. You made a great presentation. She spoke to the committee at the podium. She was a great advocate for herself and her peers in the foster care system, and she was their voice that day. So thank you for doing that. So the bill got voted out of committee that day on the gentleman from 93rd's motion. All the foster kids there got to watch it, and now it's on the House floor. Mr. Speaker, I'm going to let the gentleman from the 23rd, who again deserves the primary credit among those of us in the House for why this bill is here today, and he'll tell you how that happened. Thank you, Mr. Speaker. That's a brief description of the bill, and I will urge passage.
Gentleman from the 23rd, Delegate Worrell.
Well, thank you, Mr. Speaker, and thank you to the Chairman of Judiciary, and thank you to Ms. Curry for doing what she has done. So just a little background. Last summer, we had many foster children here from Turning Point. It was a great day. They had a mock session, and I met Ms. Curry, and the first thing she did was come up to me and give me a bill idea. And I keep copies of her handwritten bill here on my desk, and very grateful to that she brought it, and I thought it was a great idea, and worked with council to write this bill up. But I want to be clear, this bill may have my name on it, but it's not my bill. This is Ms. Curry's bill. And so with that, I will read her testimony about this bill. And I find it appropriate that her notes say, this isn't a speech, it's a mission on the top of it. And she says, so before we begin, I want to say thank you to everyone for this wonderful opportunity, and thank you for the opportunity to address this important proposal that aims to enhance the rights of children in the foster care system. Implementing the right for children 13 and up to receive proper notice about upcoming hearings that could impact their lives is a crucial step towards fostering transparency and empowerment. By ensuring that a child's guardian ad litem or legal counsel not only informs them of these hearings, but it also allows them the choice of attending. We are taking measures to give children a voice in a process that affects their future. Throughout my own experiences, I've spent years feeling lost and blaming myself for circumstances I didn't fully understand or even know of. And the reason is miscommunication and being uninformed. As someone committed to pursuing a career in social work, I see the potential for transforming change through these proposed rights. Let's work together to ensure that our foster care system not only supports the children, but empowers them to be a part of the conversation regarding their own lives. Together, we can create a brighter, more inclusive future for children who need it most. Those are words of a now 18, but a 17-year-old foster child who I think did an amazing job. I'm so proud of her for doing so. And once again, this is her bill, Mr. Speaker, and I urge passage.
Is there debate on the bill? If not, then the question before the House is, shall the bill pass? Those in favor of passage of the bill will vote aye. Those opposed will vote no. The clerk prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result on that question. There were 96 ayes, 0 nays, and 3 members absent. A majority of the members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
House Bill 4749.
Are there title amendments?
Delegate Akers moves to amend the title.
The question is on adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. The chair declares the title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate for the bills on third reading.
Committee substitute for House Bill 4893, increase the penalties for contempt of court and a magistrate court.
The question before the House is, shall the bill pass? Are there objections to having the bill explained in lieu of having the bill read? No objections are heard. Gentleman is 6, Douglas Stevens, to explain the bill.
Thank you, Mr. Speaker. This committee substitute amends the West Virginia Code to increase the fines related to finding of contempt by a magistrate, and also permits a magistrate to order completion of community service. For a third offense of contempt in the same matter, the committee substitute increases the fines and allows for alternative sentencings to be utilized at the discretion of the magistrate. This is a short description of the bill, and I urge passage.
Question again before the House is, shall the bill pass? Is there debate on the bill? If not, those in favor of passage of the bill will please vote aye. Those opposed will please vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will please close the machine and ascertain the result on this question. There were 95 ayes, 0 nays, and 4 members absent. A majority of the members having voted in the affirmative, the chair declares the bill passed. The clerk will report the title.
Committee substitute for House Bill 4893.
Are there
Delegate Akers moves to amend the title.
The question now is on adoption of the title amendment. Those in favor of adoption of the amendment will please say aye. Those opposed will please say no. The ayes have it. Title is amended by and remain the title of the bill. The clerk will please communicate the action of the House to the Senate for the bills on third reading.
Committee substitute for House Bill 4198, E-Verify Safe Harbor Act.
Ladies and gentlemen, this bill was advanced to third reading with several amendments pending and the right to amend. We do have 2 rather comprehensive and competing amendments. We'll begin with the first of the 2 comprehensive amendments. At this time, the first of them, clerk will please report the first of the 2 comprehensive amendments.
Delegates Ridenhour, Coop Gonzalez, and McGeehan move to amend the committee substitute. This is HFO Ridenhour, Coop Gonzalez, and McGeehan, 2-9 number 1, revised 2.
Ladies and gentlemen, this is a primary amendment. This is a primary amendment, so at this time, for no objection, Chair will recognize the sponsor to explain the primary amendment. No objections are heard. Shall recognize the sponsor to explain the primary amendment. The gentleman from the 67th, Coop Gonzalez, is recognized on the primary amendment.
Yes, thank you, Mr. Speaker. The amendment to the committee substitute adds back in the requirement for using E-Verify for all private employers in the state. E-Verify is free, safe, and secure and simple to use. It provides participating employers an automated internet-based resource to verify the employment eligibility of new hired employees. Almost 1 million employers are registered and E-Verify users. Participating employers electronically enter information from a Form I-9, which is the paper-based form currently required to verify the work eligibility of all new hires. E-Verify checks the information against records in the Social Security Administration's database and the Department of Homeland Security's immigration databases. E-Verify also utilizes special safeguards to ensure that employees are not discriminated against and their personal information remains private. It also allows individuals to self-check their records to uncover possible typos and errors. This amendment to the committee substitute also makes minor changes to the progression of penalties for noncompliance and leaves the indemnity portion of the committee substitute in place. A bill identical to this amendment was passed 2 years ago by this House with bipartisan support. It also mirrors the federal efforts of U.S. Senator Shelley Moore Capito, who is pushing for a nationwide E-Verify mandate. I urge adoption.
You've heard the primary amendment explained. Clerk will now please report the first of the secondary amendments.
Delegate Fehrenbacher moves to amend the amendment. This is HFA Fehrenbacher 2-10, number 1.
Gentleman from the 11th, Delegate Fehrenbacher, is recognized to explain the secondary amendment.
Thank you, Mr. Speaker. The text of the amendment basically requires that should the amendment pass, that it would only be applicable to those employers with 25 or more employees. That is the basis, and I will address other comments on the primary amendment at a later time. Thank you, Mr. Speaker.
Okay, the question now is on the secondary amendment, just explained by the sponsor. Secondary amendment only. Is there debate on the secondary amendment? Chair recognizes the gentleman from the 100th, Delegate Ridenhour.
Will the chairman of GovOrg rise for my question? Are all companies required to fill out I-9s?
Largely, yes. There are a few narrow exemptions. Individuals hired on or before November 6, 1986, continuing in their employment and having a reasonable expectation of employment at all times. Individuals hired for employment in the Commonwealth of the Northern Mariana Islands on or before November 27th of 2009. Individuals employed for casual domestic work in a private home on a sporadic, irregular, or intermittent basis, and independent contractors or individuals providing labor if they're employed by a contractor providing the services.
Okay,
But
my
beyond
hearing
that,
isn't
mostly.
great, but I didn't hear anything about a size of company or the numbers of employees in a company being.
No,
so
no limit on numbers.
They would be required to, all employers would be required to fill out I-9s, correct? For
Correct.
all of their employees?
Correct.
Okay, and this would, the E-Verify system, as I understand it, is a simpler process than filling out the I-9. Is that correct?
Well, the I-9 will still be required, but yeah, the E-Verify system is very straightforward.
It's very simple to do. So this would be creating a difference between two basically similar, if not virtually identical, systems. So we have companies of a certain number that would not be required to use what appears to be a much simpler process than a more complex process. Is that correct?
Well, as I understand the gentleman's amendment, it's simply going to exclude those with 24 or less employees from the E-Verify check.
So we would be making essentially a dual process.
Yeah, you would create two classes.
Would there potentially be a conflict in that in terms of how we're looking at an I-9 process and a E-Verify process for different sizes of companies?
I'm not sure if you could classify that as a conflict in that you would still have I-9 required for both, but they would certainly be treated differently if the amendment were adopted.
Okay, very good. Thank you.
Thank you.
Thank you, Mr. Speaker.
Chairman from the 67th, Delegate Coop Gonzalez on the secondary amendment.
Thank you, Mr. Speaker. Will the sponsor of the secondary amendment yield?
Yes.
Thank you. So just kind of going off the discussion from the gentleman of the 100th, you're aware that every employer has to fill out an I-9, is that correct?
Yes. My amendment does not preclude that requirement.
I understand. In your opinion, why should businesses with less than 25 employees be exempt from verifying their I-9 records?
As your amendment is developed, it requires all private and public employees to utilize the E-Verify process to verify employment, or that they're appropriate for employment. Today, 39 states do not require private employers to utilize E-Verify. There are only 11 states that require private employers to utilize E-Verify, and some of them have size requirements, so there are exemptions.
Yes, but my question is, why don't you believe that businesses with 25 or less employees should have to verify their I-9 records that they have on file, which they're legally required by federal law to do?
That they're legally required by federal law to do what?
They're legally required by federal law to fill out I-9s and to keep them. Why, in your opinion, should businesses with 25 employees or less not have to verify those records?
An employer with 24 or fewer employees could indeed use that I-9 form, create those records, and keep them in file and satisfy the current federal requirements to verify the employability of their employees.
But
I'm not suggesting they would not
in your opinion,
have
they
that
should,
requirement.
they don't have to, though, in your opinion. In your opinion, they shouldn't have to, though.
I'm not understanding. There is an I-9 requirement that today in the state of West Virginia applies to all employees, private or public. That will stay with the adoption of my secondary amendment. So a small employer, a small private employer, as well as a small private employer would still require that I-9 requirement.
And that's not what I'm talking about, but I'm talking about the E-Verify system, which you are exempting businesses with less than 25 employees from having to use. I'm just asking, what is your reasoning in exempting them from having to verify those I-9 records, which they are legally required to store?
Let's say that I have a small operation. I have a store in some place where I may not have readily available internet access. Let's say I would like to hire and pay my son, my biological son, to work in that store. I would have to have my son submit, or I would have to, on behalf of my son, submit that and have it go through the system. If it came back because I miskeyed something and it came back and said, oops, I got a red X instead of a green check mark, I am ostensibly in violation of this E-Verify requirement.
That's not true. You would not be in violation if you get a tentative non-confirmation, which is what happens if there is some sort of typo or something like that.
But when do I have to do something with my son, who is my employee, because I have not taken the effort or I never cleared this?
Let me ask you this. Does federal law give you an exemption from filling out an I-9 because you're hiring your son?
No, sir. I'm not saying I wouldn't
Then
fill it out.
why should there be an exception for E-Verify, which just checks the information on the I-9? That's all it is. Are you familiar with usually how many minutes it takes to verify someone on E-Verify?
I heard testimony from someone that said it was 45 seconds, but I've also heard of cases where the confirmation failed and it takes days or weeks, and I don't know what happens when there's a federal government shutdown.
Are you familiar with
whether or not
what percentage of those cases?
Happen.
Are you familiar with?
Gentleman will state the point. If it's related to a colloquy, the chair's going to rule on it already.
Thank you, Mr. Speaker.
Gentleman's recognized to ask questions. Gentleman has risen to answer questions. The chair will ask all the members to confine it to that.
Yes, Mr.
Gentleman is still recognized.
Are you familiar with what percentage of cases actually reflect that? Like what the percentage number is of people who get something wrong and they have to go back and figure it out that eventually get employed?
From an online search, I heard about 1.5%.
It's actually 0.17%. So 1.5% is the number of people who choose, not to dispute it, presumably because they're here illegally or not authorized to work. Mr. Speaker, I'd like to speak to the amendment.
The gentleman is recognized.
Just for a lot of the reasons that I listed just in the dialogue with the gentleman, I believe that his amendment undermines the primary amendment, and for that reason, I urge rejection.
Question still on the secondary amendment. Gentleman, the first, I got McGeehan's recognized on the secondary amendment.
Yeah, thank you, Mr. Speaker. My colleague from Berkeley County District 93rd with the great socks on today, yield.
Gentleman does yield.
You used to, well, you still do, I guess, own a small business, and you used to own, I think, another business, pretty small, used E-Verify, and maybe you had a dozen
Yeah,
or
when I
so.
first immigrated to the United States, I was working in California. I used E-Verify through multiple businesses for many years. It was one of the first to pilot that program.
And when you owned, I think, one business, maybe starting out or later in life, I'm not sure, you had about a dozen employees maybe at one point when you were using E-Verify?
Yes, that's true.
Was it pretty easy for you to use?
It's extremely easy. And even if you enter the information incorrectly, you can go right back in and enter the information correctly.
So even for this Luddite here, it would be pretty easy for me. Okay.
If I could operate it, any of you guys can operate it. I found it very helpful because I didn't have to make those decisions when looking at somebody and trying to decide if they were illegal or if they weren't illegal. I was an immigrant myself. I had a green card. It does take into account for that, but I found it very helpful.
So in a way, I think, I'll ask the question, in a way, I think you're getting at the epistemological problem of knowledge. Like you are absolved, it kind of protects you, right, from certain things.
As a business owner, it helps indemnify your business so that if something comes up down the road, you can say, this third party has verified the employment, and I don't have any liability.
And you've had plenty of small businesses, dozen, maybe less, used E-Verify, no big deal, right?
I own multiple businesses with small employees, yes. Well, small amounts of employees, not small employees.
Thanks.
Thank you.
Question is still on the secondary amendment. Is there further debate on the secondary amendment? Gentleman from the 36th, Doggett Green, is recognized on the secondary amendment.
Thank you, Mr. Speaker. I appreciate the intent of the gentleman for the secondary amendment. I would like to rise in opposition. I feel like that this would create a threshold of a two-tier system, one that sets rules for large employers and a different, weaker standard for smaller employers. You know, whether an employer has 2 or 2,000 employees, I feel like that everyone should be E-Verified. You know, this would actually create an incentive to structure businesses to stay under the threshold. Would make enforcement more complex and inconsistent, and it would shift violations towards smaller operations where oversight is already hard as it is. Mr. Speaker, I would urge rejection.
Gentleman from the 29th, Doggett Dillon, is recognized on the secondary amendment.
Thank you, Mr. Speaker. West Virginia has a number of cyclical industries, businesses of approximately 20, 25, 30 employees. And in any given year, those businesses might fluctuate from 20 employees in one year. They might have 30 employees the next year. It can go up and down. This 25 employee threshold seems arbitrary. It seems hastily put together. I don't think it helps the intention of the underlying amendment. I don't think it helps the bill. So I'm going to oppose it. Thank you, Mr. Speaker.
Are there other members who wish to speak on the secondary amendment? If not, yes. Lady from the 52nd, Doggett Howe, is recognized on the secondary amendment.
Thank you, Mr. Speaker. May I speak to the bill?
You may speak to the secondary amendment.
I'm sorry, the secondary amendment.
Yes, lady is recognized.
All right, thank you, sir. So in West Virginia, we are known for a state of small business owners. In this state, we have highly intelligent business owners who follow the rules every day. They work to strive for our state. They pay their taxes to help keep our state in running order. The one thing you have to consider is that we debated a bill previously where every vote matters. Now we have every employee matters. I will speak against this amendment and urge rejection, please.
Gentleman from the 27th, Doggett Amos, is recognized.
Thank you, Mr. Speaker. The gentleman from the 11th yield.
Thank you, gentlemen. Can you speak to this process? Is there a cost associated with this E-Verify system?
My understanding is that the software or the application, whatever, is readily available from the federal government, and there is no cost to utilize it, other than if you do not have, if you will, that type of connectivity. There was a question I had heard earlier in the day about what would happen if the Amish perhaps had a roof business and they hired members of their community and they don't utilize that type of technology, then they would ostensibly have to hire a third party to do this E9 or this E-Verify for them if this was to, occur.
Very good. Thank you, gentlemen. Thank you, Mr. Speaker. That's all.
Gentleman from the 86th, Leggett Ward is recognized.
Thank you, Mr. Speaker. Speak to the secondary amendment.
Yes, gentleman is recognized.
Thank you. Everybody in this room represents a different group of people, but as I've traveled across the states and talked to other delegates, most have been approached by their constituents with a simple plea that, will you do everything that you can to ensure that only U.S. citizens are hired in the state of West Virginia? Each one of you has to answer your constituents, but this is not a time to worry about having to really go out of your way and verify that your biological son is a legitimate U.S. citizen. If you want to support the secondary amendment, make certain that you go back to your constituents, and when you tell them or they ask you, did you do everything that you could to ensure that only U.S. citizens are hired in the state of West Virginia, make certain that you tell them, yes, but I did everything I could to water down the bill. It's a bad secondary amendment. I would urge everybody in this room to be faithful to your constituents and vote no on the secondary amendment. Thank you, Mr. Speaker.
Gentleman from the 82nd, Doug McCormick is recognized.
Thank you, Mr. Speaker. I would urge adoption, and I'll tell you why. Because to me, this whole thing is not about immigration. It's about small businesses and government regulations trying to tell me how to run my business. Small businesses under 25 employees don't have HR departments. They don't have somebody to, maybe even the same person each time to do these tasks. And we get lost in the whole immigration part of this. Look, I came here, and the first thing that, when my feet hit the floor every day, I'm looking out for small businesses and business in general. There's a list here, and I'm not even gonna read them all, of business-related associations that we all know and that are against this. And it's not because we're anti-immigration. We're against any immigration policies. To me, it's about regulations. We need to get the government out of our small businesses and have less regulation, not more. We talk about that all the time in here. Get government out of our lives, get government out of our business, let me run my business. This is it. Now, it's gotten tethered to a really big emotional issue. And I don't see the connection. I think that small businesses have enough problems just making payroll and having people wearing different hats, doing different things on a daily basis. We're who employ West Virginians. Look around. How many people here are or have family or own small businesses and have less than 25 employees? It ain't easy. It ain't easy. And it's almost like death by 1,000 cuts. Is this one form that we have to fill out going to ruin everybody's day every day? No, it isn't. But you know what? It's just one in a long line of things that we've got to do, that if we don't do it right, we get in trouble. We could lose our business license. People like Delegate Fehrenbacher who recognize that, and we've discussed this ad nauseum. I hope I'm not out of line, Mr. Speaker, but I would urge rejection of the initial amendment and just nip all this in the bud, as Barney would say. I'm not against E-Verify. It's a pretty good tool. But why can't we just make it a tool? Why does it have to be mandatory? Why do we have to do it? I like the committee substitute that we came out with initially. I voted for it. I mean, you can use E-Verify as a tool, but there's a lot of problems with these amendments. You know, the word knowingly is the way I understand it. If you just do it wrong, you've knowingly done it. Do I need to worry about that? Delegate, do I need to worry about that every time I hire somebody? No, I shouldn't have to. So I'm a proud small business owner. Everybody in this room knows that. I stick my nose in this stuff when it comes to things like this, and I'll defend it to the end. It's an unnecessary hardship. It's an unnecessary hardship. So, again, I may be offline here a little bit. I urge rejection of the original amendment. I like the 25-person, under 25. It at least gives us a little protection. But the whole thing is a bad idea. It's a bad idea. And I urge rejection of the original amendment. Mr. Speaker, thanks for the time.
Gentleman from the first is recognized on the secondary amendment.
Thank you, Mr. Speaker. Will the chairman of the Committee on Government and Organization yield?
Certainly.
Gentleman does yield.
Thank you. It's my understanding you represent a district that has a large Amish community. Is that correct?
Yes, large and growing.
Right. And you've done several things for them over the years that they've requested with different policies, right?
Yes.
It's been sort of insinuated that they would have problems with this. In your experience within the community there and your district, is that the case, or?
They are tend to be very successful business operators. They employ third parties to drive them often, and certainly could employ third parties to manage the system for them if they did not have the electronic wherewithal.
Okay. All right. I thought that would be the answer. It's a little nifty when people start throwing out some radical appeals, right? Objections. Okay. Thank you. Will the gentleman from the 82nd please yield?
Sure.
In your talk there, I took note, you mentioned there were several interest groups opposed to this. Did you mention that, right?
I did, yeah.
Right.
There's a lot of people opposed to it.
Sure, you mentioned several associations and interest. Can you name a few? I assume that you know who
Well,
they
it's
are.
the same ones that have emailed everybody and texted everybody the last couple of days. It's the associations that represent business, the Business and Industry
What are those
Council. Well, I'll
associations?
tell you.
Can you tell
It's the
me
Business and Industry Council, which is 24 different associations. The contractors, the oil and gas folks, the chamber folks, so pretty
Chamber of
much from all
Commerce.
walks of business.
Did you say the Chamber of Commerce? The Chamber
Pardon
of
me?
You said the Chamber folk. You mean
They
the
were
Chamber
one
of
of them,
Commerce?
yeah.
Okay.
Yep.
And so you believe they oppose it, of course, on principle because checking a free website is very burdensome, right?
They oppose it for what?
You believe, then, according to your rhetoric you just gave in that great speech, that those interest groups that you were appealing to as authority oppose this policy here, this amendment, because it's so burdensome for their businesses to access a free website, right?
You'd have to ask them why. I just know that they do.
Right.
I told you why I do.
Sure. But you really believe that?
Believe what? That they
They
oppose
oppose it because it's just a burdensome regulation.
Well, like I said,
do you believe that?
I do believe that, but you'd have to ask them why they oppose it.
Right. Well, you said you believe
That's what
they
I
oppose
think.
it because, okay, you do.
You asked me what I
So you
think.
believe. Yes.
That's what I think.
Okay. So you don't think they would oppose it perhaps because they love to make cash and money above all else, right? Even if it means hiring illegal immigrants?
Love it because they love to make cash and money? Is that what you said?
Even at the expense
Isn't
of
that
our
the
own
point of a
citizens?
business, to make money?
I don't think you understood my question. Can I ask again?
Sure.
You then don't think it's probably more reasonable, based on my experience anyway, that perhaps they don't oppose it based on some sort of principled stand that it's just too burdensome with this new little regulation that's been around forever, a free website. Perhaps they oppose it because a lot of these associations that you just named love to make money at the expense of our people through illegal labor. You don't think that's more plausible?
I think that's not true at all. I don't think they are making money. I do not think.
You don't think they're making money?
For the record, I want everybody to hear me say this. For the record, I do not believe that any of these associations that we're talking about make money at our expense with illegal aliens. So the answer would be no to that.
Okay, so your answer is no. You believe it's a principled stance because it's just burdensome, right?
I do believe it is, yes.
Okay, yeah, I rest my case. Thank you.
Is there other debate on the secondary amendment? Gentleman from the 100th, Ridenhour is recognized on the secondary amendment.
Will the chairman from GovOrg yield?
Sure.
I'm confused. I heard the gentleman from the 82nd state that this would be a burdensome process. Can you describe what it takes to actually do an E-Verify versus what it takes to do the I-9 process?
Well, you actually use the I-9 paperwork for the E-Verify process. So the burden beyond what you already have to do is simply entering that information, that data into the website and getting a confirmation, a denial, or a temporary denial.
So it's essentially the same process, just electronic. And you get an instantaneous or virtually instantaneous.
In the vast majority of the cases, yes.
Okay. And then you can don't have to worry anymore about whether or not you've potentially hired an illegal alien because you're indemnified. Is that correct?
Correct.
Okay. So you don't have to worry. You've got an easier process. Okay. I'm not sure I understand how that's burdensome, but it actually seems to me to be a far simpler process. Okay. Thank you very much. Permission to speak to the secondary amendment.
Gentleman is recognized on the secondary amendment.
I mean, a lot of this discussion has been relative to what burden this might be on small business. My family owned a small business for an extended period of time. I worked in it. It was a sawmill. We had between 6 to 8 employees, depending upon who was in jail at the time, since sawmills are not exactly the most conducive environment to comfortable work. And we attracted a group that I loved. I mean, my coworkers were terrific. They were all legal citizens. Most of them had spent some time with law enforcement, not on the blue side, but on the other side. We kept those records. My mother kept those records. It was not burdensome to keep the types of records that we're talking about here. She had to maintain records for all kinds of requirements that the federal government and the state government put upon us. That included filling out tax forms, et cetera. All of those could be considered burdensome. Anything that the government does potentially could be considered burdensome. This is just a simple requirement. It's about as easy as you can get. It essentially electronically duplicates a more complex, slightly more complex process in the I-9. There's no rationale that I can see for us to oppose some kind of a simple process. And again, this is something that small businesses are required to do. They are required to fill out an I-9. They're required to fill out their tax forms. They're required to keep records. We require them at the state level. The federal government does the same. We need to basically ensure that all of our businesses are complying with not only the I-9 process, but frankly, any kind of process that will keep illegal aliens from being allowed to work in our country. Thank you.
Gentleman from the 11th, Dr. Fehrenbacher, to close debate on the secondary amendment.
Thank you, Mr. Speaker. Colleagues, I'll just be very blunt and skip to the end. I do not support the amendment. And the reason why I brought up, I do not support the primary amendment. The reason why I brought up the secondary amendment is, if you will, to lessen the burden on some small employers. The delegate from the 67th said that, oh, the error rate is 0.017%. There are 720,000 workers in West Virginia. I realize every single one of them has been grandfathered by the language in the primary amendment. However, even at that error rate, there are 122 people that would get a red check mark. They would not pass for some reason. A transposition error or something else would preclude an employer from hiring them because they failed the E-Verify check. Let's talk a little bit about E-Verify. It's been said that lots of states have this. An employer can elect to use that. The reality is that there are 27 or 29 states that have no E-Verify legislation. There are 12 states that require it for public employees or federal contractors. Okay? That brings us to 39 or 41 states that require E-Verify. There are 9 others that require E-Verify for private employers, for David McCormick's business, for anybody's small business. The state of West Virginia will potentially become the fourth state with this modification, with this amendment, to require it for all employees. Alabama, Arizona, Mississippi are the three others that currently require E-Verify for all private and public employees, regardless of the size of the company. Last point I'll say is that this state is going to get $1 billion for internet service, because it's estimated that about 10% of our population has no internet service. So I guess those businesses in those locations that don't have internet service are going to move to where they get a signal and hope that their third-party provider or their cell phone service is going to allow them to perform this E-Verify check, because I-9s are not satisfactory. Thank you for your attention. I think this is a reasonable compromise based upon the practices of other states. I would support the passage of this secondary amendment. Thank you.
Debate on the secondary amendment has been closed. Question before the House is, shall the secondary amendment be adopted? Roll call is requested. Is the request sustained? Request is sustained. Question is, shall the secondary amendment be adopted? Those in favor of adoption of the secondary amendment will please vote aye. Those opposed will please vote no. The clerk will prepare the machine. Have all members voted? If so, the clerk will please close the machine and ascertain the result. On that question, there are 40 ayes, 55 nays, 4 members absent, less than a majority in the affirmative. The chair declares that secondary amendment lost. Are there other secondary amendments?
Delegate Green moves to amend the amendment. This is HFA Green 2-9, number 1.
Chair recognizes the sponsor, gentleman from the 36th, Delegate Green, to explain the secondary amendment.
Thank you, Mr. Speaker. This amendment to the amendment modifies one subsection, subsection E3. It sets a clear, reasonable deadline to act once it is discovered that an employee has been hired without the E-Verify process being performed. The employer must initiate the E-Verify process within 2 business days. And secondly, it allows a short, defined completion window. After the initiation, the employer may continue employing the individual for up to 20 calendar days to allow the federal verification process to conclude. Simply, this change would allow the employer who is caught unawares to have a short, defined opportunity to fix the problem immediately, rather than forcing them to fire the employee and then rehire that same person once the verification is completed. I urge adoption.
You've heard the secondary amendment explained. The question now is, shall the secondary amendment be adopted? Is there debate on the secondary amendment? Chair recognizes the gentleman of 67, Dr. Coop Gonzalez, on the secondary amendment.
Thank you, Mr. Speaker. I've reviewed the amendment along with the gentleman, and I think it actually clarifies a technical problem the primary amendment had, so I urge adoption.
Gentleman from the 100th on the secondary amendment.
I would also speak in favor of the this amendment to the amendment. I think this does help protect our small business owners. It does help protect against any kind of potential problems that E-Verify might have, so I would urge support for the secondary amendment.
Is there further debate on this secondary amendment? Does the gentleman wish to close debate on the secondary amendment? If not, the question before the House is, shall the secondary amendment, as explained by the sponsor, gentleman of 36th, be adopted? Those in favor of adoption, please say aye. Aye. Those opposed, please say no. The ayes appear to have it. For the ayes have it, chair declares that secondary amendment adopted. Are there other secondary amendments?
Delegate Levitt moves to amend the amendment. This is HFA Levitt 2-10, number 1, revised.
Question now is on adoption of the secondary amendment. Chair recognizes the sponsor, gentleman from the 53rd, Delegate Levitt, to explain this secondary amendment.
Thank you, Mr. Speaker. This would just make a handful of small changes. First is to take the range for potential financial penalties in the amendment that's being considered and fix that at $500 rather than the range. Second is to add, where there is a second or third violation, the opportunity for the business to have notice and an opportunity to be heard pursuant to our State Administrative Procedures Act. Thank you. I urge adoption of the amendment.
You've heard the secondary amendment explained. Is there debate on this secondary amendment? Gentleman from the 67th, Dr. Coop Gonzalez, is recognized on the secondary amendment.
Thank you, Mr. Speaker. I've also reviewed the gentleman, 53rd. I've reviewed the secondary amendment from the gentleman from the 53rd, and I believe it strengthens the primary amendment, and it's a good thought. Glad he introduced it. Thank you. Urge adoption.
Is there other debate on the secondary amendment? If not, the question is, shall the secondary amendment be adopted? Those in favor of adoption, please say aye. Those opposed, please say no. The ayes have it. Chair declares the secondary amendment adopted. Are there other secondary amendments? If not, we do have two competing primary amendments. The primary amendment as amended, sponsored by the gentleman, the 67th, Dr. Coop Gonzalez, and gentleman, the 100th, Doug Ridenhour, as well as a competing secondary amendment sponsored by the gentleman, the 29th, Doug Dillon. It's the chair's understanding that the members have conferred, and we wish to proceed now with consideration of the primary amendment as amended at this time. So at this time, is there further debate on the primary amendment as amended? Gentleman from the 45th, Delegate Brooks.
Thank you, Mr. Speaker. I rise today in support of the gentleman's amendment. Got a few things I'd like to say regarding this issue. First, I'd like to say that E-Verify protects jobs for Americans and for those who are here legally. I personally ran on putting Americans first, and more specifically, putting West Virginians first. This system supports my efforts to do just that. It's not that I don't care about non-Americans. Lord knows I don't want anything bad to happen to anybody. But I do care about our citizens more, and for that I will not apologize. Secondly, mandatory E-Verify, as this amendment would require, will remove one of the primary incentives for illegal immigration into our state. If we are serious about securing our borders, and most of us say that we are, then E-Verify is a wonderful tool to use to support those efforts. Illegal aliens go where the jobs are. With mandatory E-Verify in our state, we will remove one of the main reasons for them to come here. Why is this important? The safety of West Virginia citizens is why. In 2025, crime statistics showed that almost 1,000 illegal aliens were convicted of a violent crime in our country. I want to talk about just one of those convictions. Samantha Daly was an American citizen and a West Virginia resident. She was a 32-year-old mother of two. On May 6, 2024, Samantha's body was discovered in Berkeley County. She had been murdered and her body set on fire. She was burned so severely, authorities initially could not tell if the body was that of a man or a woman. Her killer, an illegal alien, was convicted of her murder on July 23, 2025. He was one of those 1,000 convicted of a violent crime last year. Samantha's killer had prior convictions for murder, sexual assault, aggravated robbery, DUI, and narcotics. What would to death, so he was making money somehow. My concern is for West Virginians. We have to ask ourselves if it is worth the risk to our people to continue to allow those here illegally to stay. Are we willing to risk another murder of one of our citizens? It's all just hypothetical until it's your daughter, until it's your wife, your sister, or your mother. I promise you, if something would happen to one of them, you would have wished that you would have done something that could have helped prevented it. Samantha's children will now grow up without their mother, and her family will move forward without her in their lives. We must do better. Mandatory E-Verify will help prevent this from happening. It would be, if it would just prevent one murder, I would argue it would be worth it. Thirdly, mandatory E-Verify creates a level playing field for all of our West Virginia businesses. Law-abiding employers who follow the rules should not be undercut by competitors who cut corners and hire those in our country illegally, oftentimes at lower wages. That kind of unfair competition hurts our responsible business owners. This amendment, these gentlemen's amendment, would change that. Lastly, our citizens are the ones who pay for us allowing illegal aliens to be in our state. Last year, 1,000 illegals were booked into the criminal justice system in our state. Each day that each one of these individuals is in one of our jails or our prisons cost the taxpayers $67.27. That adds up quickly. Do you want to help your county with its jail? Pass these gentlemen's amendment. Those that illegally get sick too. Do you want to help with our overburdened hospitals and emergency rooms? Not to mention the medical costs that are shifted to our citizens due to those who have no insurance. Pass this amendment. Those living here illegally have children too who need to be educated. Want to help our overburdened teachers and school systems? Pass these gentlemen's amendment. Those here illegally need a place to stay as well. Want to help with the housing crisis we currently have in our state? Pass this amendment. E-Verify is not complicated. It's a fast, free, and widely used system that cross-checks employment eligibility with federal databases. The results are often returned in seconds. It does not, in my opinion, pose an undue burden on our employers. Our people are worth our support of this amendment and the utilization of this system by all of our employers. I will be voting for this amendment, and I encourage my colleagues to support its adoption as well. Thank you, Mr. Speaker.
Gentleman from the 7th, Delegate Sheedy is recognized on the amendment.
Thank you, Mr. Speaker. Delegate Gonzalez, will you yield?
Yes.
Sir, have you ever heard of Fish Creek General Store?
I don't believe I have.
Have you ever heard of Adeline, West Virginia?
No,
There's
sir.
some small town, that's a small town and a small store in my district that employs 4 people. Yeah, I've been contacted by some of the other major organizations that were mentioned previously. I've also been contacted by several small business owners in my communities. They don't want it. They don't want the amendment. They would support the bill. Right now, I don't know where I'm at as far as the vote goes. I'm going to say that I'm against the amendment, but I would be for the bill as it was written. Thank you, Mr. Speaker.
Gentleman from the 29th, Delegate Dillon is recognized.
Thank you, Mr. Speaker. I rise in support of the amendment offered by the gentleman from the 100th and the gentleman from the 67th. You know, as a father of 4 daughters, I think about some of these terrible cases that have happened across the country, and I believe we owe it to our citizens to ensure that we have a safe and secure state. I believe this amendment is a strong step in that direction. And I also believe that we owe it to our citizens to protect their jobs, to make sure that someone isn't able to come in from out of the country and take away a job that they should be able to work at to support families. So for those reasons, I appreciate the gentleman for offering this amendment. I will be in support of it. I would urge you also to support the amendment. That's all I have. Thank you.
Gentleman from the 64th, Delegate Burkhammer is recognized.
Thank you, Mr. Speaker. Would one of the sponsors yield for a couple questions to help me clarify something here?
Yeah, absolutely.
All right, thank you, sir. I want to focus on, I have no issue outside of any portion of this bill other than one I need some clarification on, and it's in the penalties section. So as the bill stood, there was a $100 fine for record keeping, but we went through and struck all of the penalty around if you actually were hiring an unauthorized worker. Is that correct?
That's correct.
So now if you hire an unauthorized worker, you're not subject to any criminal crime. There were some misdemeanors listed, no financial penalty. You only lose your business license.
If you're referring to fines specifically, no, you cannot use those as a mechanism for enforcement. So
Okay.
you'd be correct.
All right, but then your amendment goes in, and there was a secondary amendment that adopted that actually increased the penalty for from $100 to $500 around the record keeping. Is that correct?
That's correct.
All right, so is the E-Verify approval, would that be considered part of the record keeping that is now necessary to do business?
It would or wouldn't? You said yes? Okay. Yes, according to counsel, it would.
Okay. So to help me walk through this, so we increased the fine for the administrative record keeping part, but we removed all of the liability and all of the fines for actually hiring unauthorized illegal workers.
Yes. And the reason why we did that is just because federal law preempts us from using fines as a mechanism. And this falls under records, which is different. I mean, it's a different part of the, I guess, I wouldn't say bill, but part of the primary amendment.
It's actually in the same part of code. So how can we impose a fine? You just said we had to remove all of these fines, but then how are we increasing a fine for not keeping the approval process? How would they not be one and of the same?
I believe that based off the federal law that's in plain language, it says that we can't use fines. I think a court would look at that and say that we're fine there, because it does give a little bit of wiggle room.
Okay. Let me walk you through this scenario. So I am an employer, and I run E-Verify, and so I get the record, and it says that I can't hire someone. They are unauthorized to work, but I have that record. So as your amendment, as this bill's written, are there any fines that can be imposed on me? I hired an unauthorized worker. You removed those fines, but I also have the record that was required.
I guess you could say that, but that would be up to legal interpretation, and I think you just read it differently than I do based off the court precedent and what plain federal language says. I think this would be fine if it went to court.
All right.
And I've conferred with several counsel on that.
So let me again understand this fine. It's now a $500 fine if I don't keep the authorization documents for every employee that I have. Is now a $500 fine per employee for every day that I was non-compliant.
I don't believe it's per employee. I believe it's per offense.
So per offense, but isn't there some language that talks of for every day that I'm non-compliant?
Okay. So just to clarify, actually, originally it was a separate offense. Actually, now we're changing it to where it's just one offense. So it's not a separate offense for each employee.
But it is per day that I'm not compliant, or the employer is not compliant. So, so a small business that failed to keep an administrative document could be fined $500 per day for every day that they were non-compliant. Is that?
I mean, as it's written, I believe that's what it says.
Okay. I appreciate you answering the questions. Thank you. So, again, I support where the bill was going, but it would appear that we are targeting the wrong people. and I've shared that concern over and over as we went through this, that I think we should target those that are hiring unauthorized workers. But as this bill is written, we actually are removing that penalty that goes after unauthorized workers. And the only thing that you can possibly, that would happen to you, is you lose your business license. But in return, what we're going to do is every business across West Virginia is now subject to a $500 fine for a mere administrative error. And I know you're probably going to get up and argue this knowingly and willfully stuff, but that is very broad when we consider that as well. So again, why are we targeting the wrong people? I agree with where we want to go with the bill, but we're not going there. We're actually stripping that out. Literally stripping out the whole point of the bill is to target unauthorized workers, and we're going to say, nope, we're not going to do that. And we're going to say it's some kind of federal law problem. It's been in our law for how long, and it wasn't a problem, but we're stripping it out, and we're saying small businesses, $500 fine because you're not doing your paperwork right. And we passed an amendment that said we want to give our small businesses a little bit of time for 20 days on it. Quoted in that, knowing that it was a burden for small businesses. I'm telling you guys, you really do not understand and grasp the magnitude of what it's like to run a small business. Oftentimes from your kitchen table in the wee hours of the night of trying to make it, trying to grind it out, one more burden. One more burden that you've got to do, that you've got to jump through. And if you don't, $500 fine, day after day after day. We're putting them out of business is what we're doing. We're targeting the wrong people. If the intent is to go after people that are hiring unauthorized workers, go after them. But I would suggest that we leave our accountants and our bakers and our small business guys, I suggest we leave them alone. And we figure out a way of how we can support them. Target the right people. It's time to unburden those that are burdened. I can't support it.
From the 100th, I get Ridenhour.
Will the gentleman from the 67th yield?
Yes.
Are there penalties if, on the federal side, in the event that you do not complete and maintain your I-9 records?
Yeah, I believe so. That's against federal law.
So there are penalties for not maintaining records already?
Yeah, that's correct. I couldn't tell you exactly what those penalties are, but it is against federal law, and it is punishable.
So we already essentially are maintaining a process at the federal level that would require business entities to maintain records, which essentially are the same as this E-Verify.
That is correct.
Very good. Thank you. Thank you, Mr. Speaker.
Are there other members who wish to speak on the bill? Gentleman from the 93rd, I got Hornby. Excuse me, the primary amendment. Chairs near the primary amendment.
In favor of this amendment as a small business owner, as somebody that is verified, as somebody that keeps I-9 records, as a legal immigrant who for 10 years had to do the right thing to get my status and my citizenship. I did it the right way. I just want everybody else to do it that way too. Thank you, Mr. Speaker.
Gentleman from the 1st, I got McGeehan's recognized on the primary amendment.
Thank you, Mr. Speaker. Of course, I rise in support of the primary amendment. You know, I don't know, sometimes I think we, many anyway, in here, perhaps get caught in the nuances and miss the forest for the trees. You know, we are living in, we're not living in 1998, definitely anymore. We're not living in 2005. We're living in times that are very uncertain, very chaotic, and we're living in times that call for a little bit of what's used to be called by our ancestors of obligations. And so some of the members that have already stood up and opposed this primary amendment remind me of maybe merchants inside Rome when Hannibal slaughtered 90,000 Romans outside, about 40 miles from Rome. And then they would say, hey, don't burden me with a little bit of an obligation. The obligation is just too steep. The entire state is about to go under. 4 million, 5 million, 3 million, depending on what sources you cite, have illegals have crossed into this country in the last 4, 5, 6 years, roughly. Okay? So this isn't a static situation. If you want to be attached to the classical liberal ideology and stuck in the cave, go ahead and do that, all right? But this isn't about that. We have a problem, a massive problem on our hands. We need to preserve our state, our culture. I mean, we've seen it here incidentally. Fortunately, it's not as bad here as it is in other states. But it's not about not being compassionate. It's not about this interfering with businesses. It's a free website, for crying out loud. It's really about our state's working people. Our state's working people that are the backbone of this state. We need to also preserve and keep and hold our communities intact. That's what this is really about. You know, it's about preserving the type of jobs that sustain families, rooted families, that they can stay in one place, sustain their families, raise their children, pass on their culture and their religion that their ancestors held dear. That's what this is about. This is one little step, but that's what this is about. You know, that's what we face, and in principle, that's what this is about. It's about the trades, it's about skilled work, it's about cultivating crafts, it's about manufacturing. Those are the types of jobs in construction, things that develop good paying jobs, good sustaining work for our folks, develop the virtues, raise families, keep families here rooted in home and hearth. These arguments against this primary amendment about being so burdensome and it's a barrier, to accumulating more cash, or a barrier to small businesses, and this abstract entity, small business, Sometimes I question when someone appeals to some sort of abstraction whether a man really believes and have conviction in some abstraction, concrete loyalty to family, home, hearth. So this progress that we hear really is what they're talking about. Progress, they're reducing arguments into economics. Basically like our people are just interchangeable units, right? Corporations tied to international finance use and sometimes treat our people like they're instruments and cogs in a machine, and as soon as it's profitable to cut them loose, they do. This is about preserving our culture. That's the essence and motivation, for me anyway, to do something under our control. Because we live in unfortunately, post-liberal times and radical times. We just do. We need to protect home and hearth, protect our families, protect West Virginia, and keep it West Virginia. I support the gentleman's amendment.
Gentleman from the 11th, Douglas Fehrenbacher, is recognized on the amendment.
To no surprise, I oppose the amendment. To be additive to the things I've already said, if you look at the bill, it's a modification to 21(1)B. One of the sections that is not modified in the bill, nor in the amendment, is 21(1)B)(1). I'll read it, 2 sentences. The legislature finds that employers have the responsibility to verify the legal employment status of all persons who come into their employ and to report their employment to the appropriate governmental agencies. Employers are precluded from hiring unauthorized workers and can be penalized for doing so. That language was created and passed into law in 2002. There is further language in code where the Commissioner of Labor has a responsibility to audit and ensure that those types of processes, the age verification, the employment verification, the I-9, are being collected and filled out. To my knowledge, in the search that I've done, the Commissioner of Labor has not found problematic issues with that in the state of West Virginia. This feels like a bill in search of a problem that does not exist. The other thing I will say, to take up some of the arguments that I've heard, is that by the adoption of the requirement of E-Verify, crime will decrease. Other aspects of benefits to our citizens will increase. If I was to take that argument and try to give it credibility and say, well, by God, that's right, I would expect that those states that have required E-Verify to have similar results. To my knowledge, none of the 9 states that require E-Verify are making such claims. Alabama, Arizona, Mississippi, I don't see that they have reduced crime, that their median income or whatever other social measure that may be important has improved, and they attribute it to the passage of required E-Verify. I do not support this amendment. The original ComSub bill, to me, is adequate. I would encourage a no vote on this primary amendment. Thank you.
Sure, from the 98th, Douglas Funkhauser is recognized.
Thank you, Mr. Speaker. I would just note, for the full context of the gentleman, he did leave out one sentence there in the legislative intent of that bill passed by this legislature in 2024 is what I see on the record. Additionally, employers owe a duty to the residents of the state to uphold the intent and integrity of the general workforce due to the potential loss of revenue to the state by loss of taxes, unemployment premiums, and workers' compensation premiums. So that is the complete context and complete section there of the legislative intent for this code, which we're amending. Therefore, I simply think the amendment is modernizes E-Verify to the times of doing things online, which most businesses are very capable of doing, as spoken to today by various speakers. So I support the amendment. Thank you.
Is there further debate on the primary amendment? Gentleman from the 100th, Douglas Ridenhour.
This amendment to the bill is principally designed to ensure that we're following the law. The law is that illegal aliens that do not have work authorization are not allowed to work in West Virginia. They're not allowed to work in the United States. We have to make a determination. Are we a nation of laws? Are we a state of laws? Are we going to value the legal processes over short-term profitability? And that's in many respects what this is. We need to determine whether or not we want to employ Americans, West Virginians, and those who are legally allowed to work in the country. My wife is an immigrant. I can get her on the phone if you'd like right now. I know what her perspective is on this bill. She's absolutely in favor of this. She came into this country and worked as a legally authorized immigrant for about 7 years prior to her getting her citizenship. She is very much in favor of this. Several of her family members also came to the United States and were legally authorized. They went through the process, the proper process, to be authorized to work in the state, in the United States. And that's what this amendment is trying to do, is ensuring that those individuals, those Americans, those legally authorized immigrants who are coming to this country to become citizens, who want to try and do their best to make this a better country, are actually given the authority to do so and are not being supplanted by those individuals who don't have that authority, who are coming here under illegal means, who have infiltrated our country so that they can profit and send money back to their countries. In many respects, I respect that they want to earn a living. But we as a country are also stealing many of the best and brightest from their countries. Those countries can't improve if they're constantly sending those individuals who might want to work here. So this is a bill, as I've said, an amendment that I think will strengthen our state and our country, and I recommend passage. Thank you.
Is there any further debate on the primary amendment? If not, the question before, well, excuse me, Chair recognizes the sponsor, Gentleman from the 67th, Dr. Coop Gonzalez, to close debate on the primary amendment.
Yes, Mr. Speaker, I urge adoption.
Okay, the debate on the primary amendment has been closed. The question before the House is, shall the primary amendment be adopted? Those in favor of roll call is requested. Is the request sustained? Request is sustained. The question is, shall the primary amendment be adopted? Those in favor of adoption will please vote aye. Those opposed will please vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will please close the machine and ascertain the result. On this question, there are 48 ayes, 46 nays, and 5 members absent. A majority of members having voted in the affirmative, the chair declares the primary amendment adopted. This primary amendment having been adopted precludes consideration of the other comprehensive primary amendment. So at this time, Chair will ask the clerk, are there other primary amendments? If not, clerk will please read the bill a third time as amended.
Committee substitute for House Bill 4198, E-Verify Safe Harbor Act.
Question before the House is, shall the bill pass? Gentleman from the 68th, Douglas Phillips, is recognized.
Sorry, Mr. Speaker. We do have a title amendment also with this, with the adoption of the amendment that is going to, okay, I'm sorry, it's up there. We've had lengthy debate on this today. I won't wear anyone out anymore. I think this comes down to a policy issue, and all of us pretty well know where we're at on the policy. I urge adoption of the bill. Thank you.
Is there further debate now on passage of the bill? Gentleman from the 7th, Douglas Sheedy, is recognized.
Thank you, Mr. Speaker. Would the author of the bill please respond to any questions?
Yeah.
Thank you. As the bill is now amended, several areas in my district do not have reliable cell service or internet service. How are they supposed to submit these E-Verify now?
That's a good question. Since E-Verify is very easy to use and you could use it on any computer, you could look at a local library or a place like that. There's a lot of ways that you could accommodate, but they could do it.
Some of my small businesses don't leave to go get anything. They don't leave that area for 2 weeks. So how long how long do they have to comply with this now?
So as I understand, you can also have third parties if you don't have direct access. That's another avenue that you could do. And then also, while you're verifying them, you can still employ them provisionally. So you're not barred immediately.
Okay, what if you're in the Greenbank area of the state where there is absolutely no cell service or no internet service? What happens there?
I'm familiar with that area. That's my district. And I understand that concern. In that case, it probably would have to be sourced to a third party, or you'd have to find somewhere near where there's internet access, which you would have to use anyway if you're running a business. I believe 99.5% of business licenses in West Virginia were renewed last year online. So, I mean, it's a very general standard. It's the 21st century, and that's just how people are running businesses.
Thank you, Mr. Speaker.
Question again is, shall the bill pass? Is there further debate on passage of the bill? Does the gentleman from the 68th wish to close debate on the bill? The gentleman has waived the right to close debate on the bill. The question before the House is, shall the bill pass? Those in favor of passage of the bill will please vote aye. Those opposed will please vote no. The clerk will prepare the machine. Has every member voted? If so, the clerk will close the machine and ascertain the result. On this question, there are 69 ayes, 24 nays, and 6 members absent. Majority of the members having voted in the affirmative, the chair declares the bill passed. The clerk will please report the title.
Committee substitute for House Bill 4198.
Are there title amendments?
Delegate Phillips moves to amend the title.
Question now is on adoption of the title amendment. Those in favor of adoption of the title amendment will please say aye. Those opposed will please say no. The ayes have it. Chair declares the title amendment adopted. The title as amended by the House will be and remain the title of the bill. The clerk will please communicate the action of the House to the Senate. Are there other bills on third reading? If not, bills on second reading.
Committee substitute for House Bill 4012 relating to reducing the regulatory burden on utility companies when constructing and maintaining electric power generation and transmission facilities within the state.
For what purpose is laid in the 56 seek recognition?
Thank you, Mr. Speaker. I was hoping I could go back to introductions really quickly.
Are there objections? No objections are heard. Ladies recognized.
Thank you, guys. Just really quickly, we've got the George Washington High School girls wrestling team in the West Gallery today. They're now E-Verify experts, but also they're here to talk about sanctioning girls wrestling. If they could stand with Coach Neal and everyone could make them welcome.
Question now is on consideration of committee substitute for House Bill 4012. Are there amendments?
Delegates Street and Zeteslow move to amend the bill. This is HFA Street and Zeteslow 2-10 number 1.
Ladies and gentlemen, the chair has reviewed the amendments. There are competing primary amendments to the bill. So at this time, the chair will recognize the sponsor of the first of the 2 competing primary amendments. Chair recognizes the gentleman from the 83rd Delegate Street.
Thank you, Mr. Speaker. This, the brief summary of this amendment here is to provide that, to have the PSC provide that prior to issuing a certificate of convenience for 200 kV power lines or greater, they look at it and determine that there is a benefit to the state of West Virginia and its ratepayers. The cost of the line, associated facilities, the maintenance, prior to all of that, the PSC will determine that there is a commensurate benefit to ratepayers. No portion of construction, operation, maintenance shall be recovered unless these benefits are determined to the state and its ratepayers. That is a brief summary. Glad to take any questions.
That is the first of the 2 competing primary amendments. So at this time, the chair will ask the clerk to please report the second of the 2 competing primary amendments.
Delegates Anders, Dillon, Hillenbrand, Ridenhour, and White move to amend the bill. This is HFA Anders et al. 2-9 number 1.
At this time, the chair will recognize the sponsor, the 100th Delegate Ridenhour, to explain this secondary amendment, or this primary amendment.
Thank you, Mr. Speaker. This amendment is somewhat different from my friend's amendment. In our amendment, we're doing somewhat similar things, but we have more, I think, impactful requirements that we're levying upon the Public Service Commission, and that consists of basically requiring that the Public Service Commission not grant a certificate of public convenience or necessity for any construction of an electric line over of 200 kilovolts or greater, unless the cost of the line and associated facilities are allocated to West Virginia load-serving entities, and that no portion or cost of the construction, operation, or maintenance shall be recovered from West Virginia load-serving entities and ratepayers unless such costs are at least roughly commensurate to the benefits of such ratepayers. And we're also trying, or I'm sorry, my mistake. Too many pieces of paper. Okay. So the primary purpose of the transmission line is to serve electric load located in the state of West Virginia, and that most of the measurable capacity of the transmission line is reserved for West Virginia ratepayers, and that we want to try and ensure that at least 2 substations are located in the state of West Virginia, so that we actually gain benefit from these electrical lines as they're coming through. And that the primary capacity be used to serve those in the state of West Virginia. That's the gist of my amendment, and I'd be happy to stand for any questions.
You've now heard the 2 competing primary amendments explained. So at this time, a chair will open the floor for debate on both primary amendments before proceeding to consideration of the amendments. So debate is now open on both primary amendments. Is there debate on the 2 primary amendments? Gentleman from the 29th, Delegate Dillon is recognized.
Thank you, Mr. Speaker. As a co-sponsor on the amendment with the delegate from the 96th and the delegate from the 100th, I was also prepared to present the amendment. So I'll speak to the amendment as if presenting. While we all recognize the need for infrastructure upgrades in our interstate electrical system, which the bill seeks to address, the amendment to HB 4012 includes critical protections to ensure that West Virginia citizens are not left holding the bag with higher utility bills as a result of new 200 kilovolt and higher transmission lines being constructed. The amendment contains provisions to ensure that West Virginia citizens can benefit from the upgrades to electrical infrastructure through a requirement for substations or interconnections to be built into portions of the newly constructed line located within West Virginia. The amendment also provides for ratepayer protections by only allowing recovery of construction costs in proportion to the amount of electricity used here in West Virginia. Additionally, it prohibits the use of eminent domain to acquire private lands for corporate purposes related to transmission line construction. Finally, the amendment enforces compliance with this section of code by denial of the Certificate of Public Convenience and Necessity for noncompliance. This is a summary of the amendment. Now, to speak to the amendment, I would simply say West Virginians, we have a lot to be proud of. Our coal and gas-based energy powers a lot more than just our state. But our citizens should not be asked to foot the bill for costs associated with infrastructure that is not intended to serve West Virginians, but rather out-of-state interests. Simply because other states who have embraced the Green New Deal have failed to plan for their own energy needs, choosing instead to play a risky game of chicken with their rapidly growing electrical demands, this does not mean that they have the right to impose upon our citizens the cost of interstate transmission lines to serve their needs, nor claim property by eminent domain that rightly belongs to West Virginia families. Exporting power to other states can be a significant and beneficial part of our energy policy if we get it right. This well-crafted amendment is being offered to see that we do. Either way, West Virginia ratepayers cannot afford anything that will increase as much as 1 penny to their utility bills. For that reason, I strongly urge adoption of the amendment offered by the gentleman from the 96th and the 100th and the 29th and a few others. Thank you.
Gentleman from the 10th, Douglas Anderson, is recognized.
Thank you, Mr. Speaker. In that we have two competing amendments before us, I will address the Anders and other amendments first. One particular area, I will oppose this amendment. One particular reason for my opposition is in the building, the mandating of building 2 or more substations, it's almost like the field of dreams. Build it and we hope they will come. But as we build it, our consumers will have to pay the increased rates necessary for an installation of these facilities, whether or not we have immediate use for them or not. Secondly, on the prohibition of eminent domain, the Federal Energy Regulatory Commission, if the states do not move in this direction, they have the power to grant eminent domain for the building of these large electric lines across the country. I believe the Second Amendment offered by Delegates Street and Sotelo is superior in the fact that the key part of this amendment, I believe, is the requirement that the applicant for the building of a power line commits and agrees that as a condition of the certificate, it shall, upon receipt of a valid and approved request, serve West Virginia retail load at its sole expense, design, construct, and place in service, and offtake facilities reasonably necessary to provide such service in a reasonable time frame. That we won't build it and hope they will come and expense our ratepayers not knowing whether it is needed or not, but when and if it is needed, the Public Service Commission, through their enforcement, can facilitate the building of substations upon demand in a reasonable amount of time. The other thing I would like to point out to the body is that excuse me, the guy right now in our state, we are generating more megawatts of electricity, more gigawatts of electricity than we consume in this state. We are a net exporter of electrical generation to the rest of the country. And that is important for the creation of jobs, not only for miners in this state, but is important for the creation of the people that transport the coal on the rivers and on the railroads. We have adequate electricity to meet the needs of retail customers and manufacturers in our state. It concerns me that the prohibition or the attempted prohibition of building additional electrical capacity in this state sends a message to people that may want to invest in producing additional electricity in this state. We have recently announced in this state by electrical generators the building of gas-fired power plants in this state. And the only way that I'm concerned that we may be sending a message out, we're not interested in additional energy development in this state if we're going to paralyze the ability to transport it out of the state. I see a similarity here to the fact that sometimes one of the biggest burdens we have in the natural gas industry, of which we produce tremendous amounts of natural gas in this state, but we are choked by lack of pipelines to transport it out of state. I would like to burn more of it in state in gas-fired power plants in this state. But we have to build them, and we have to have the electrical transmission to move them out of state. If that is not, while we try to strive through our process in the state to attract business investment, to make West Virginia attractive to business to build here, and we use the electricity here, but right now we're producing more than we consume in the state, but a lot of West Virginia's jobs depend upon the production of this electricity, and we can move it out of state. FERC will grant the power of eminent domain. That is why the Anders Amendment is defective in that area, and I don't want to build something, as I said, I'll refer back to the Field of Dreams, hoping it will come. But with the subsequent amendment offered by Delegate Street and Zeteslow, it produces the situation where the Public Service Commission will move to get the infrastructure built necessary when the demand is in this state. I believe the Street-Zeteslow amendment is vastly superior to that offered by Delegates Anders and others. So I urge the rejection of the Anders amendment and the passage of the Street-Zeteslow amendment. Thank you, Mr. Speaker.
Gentleman from the 100th, Delegate Ridenhour is recognized.
Will the gentleman from the 88th rise for questions?
Yes.
Can you give me an approximate figure of the number of emails you've received from those constituents who have complained about the West Virginia legislature lowering their rates for electricity?
Lowering their rates.
Lowering, yes, lowering. As opposed to raising them, which is what we tend to do. But I just wanted to see if you
I
had
don't
a
recall
round
getting
figure.
that many complaining about lowering rates.
So that figure might be zero. Okay.
Very, very much so.
Have you heard of too many constituents who are interested in having eminent domain used in your county to take property so that a electrical line can be built to Virginia, since Virginia doesn't want to use coal, natural gas? Has there been kind of a vast increase in the number of folks who are in favor of eminent domain?
No, I'm not aware of any in my district that are in favor of eminent domain.
So Hampshire County, you think, might be somewhat unified in opposing increasing rates and the use of eminent domain to take their land?
I believe anecdotally you could say this, yes.
Okay. Would the gentleman from the 98th rise? Have you had any similar emails that are complaining about the West Virginia legislature lowering rates, electric rates?
It's definitely a concern of many of my constituents. My power bill has more than doubled the last few months, as I've seen on Facebook. Many others have as well.
Right. So, and I've received, and I believe you've potentially received, complaints about eminent domain potentially being used to seize land in our county so that they can put electrical lines over to Virginia to ensure that Virginia has some of the, Loudoun County specifically, Fairfax and others have the fastest growing, I guess, tax revenues in the country. I think that's correct, isn't it?
There's definitely a concern with the transmission lines and how that's going to affect the folks in my district, in particular where one of those transmission lines is scheduled to be expanded or somehow, some way to provide that power to Virginia.
Okay, thank you.
Gentleman from the 2nd, Douglas Zeteslow, is recognized.
Thank you, Mr. Speaker. This is an interesting time for this body and for the state of West Virginia. We come down to a question of whether we want to use our resources here or send them out of state where people will use them without question. That's happening right now. There's no disputing it. We produce 3.5 trillion cubic feet of gas in this state. We use, probably between 250 and 500 billion cubic feet. There is a lot of talk about an aggressive growth of energy production in this state. The only way that that's going to happen, and the only way that we add value to our resources, is by using them here. In order to use those resources here, we will probably end up creating electricity, at least in part, and sending it places outside of our state. If we don't want to do that, and if we see that that's a detriment to people working, which I doubt, we should start thinking about which coal-fired power plants we need to close. I stand before you and tell you all that I don't want that to happen. I don't want that to happen, and the increased value to the state by starting to use our resources here is something that cannot be ignored. We have to think about that when we are coming up with a decision in this matter. I don't want to close any coal-fired power plants. I want to open some if we can do it. I'm happy to do that, and I'm happy to work on that. I feel that our amendment that Delegate Street and I have sponsored, along with other people who've helped us work on it, will do that, will allow that to happen. I do not believe that the other amendment will allow it to happen. The other thing that we have in this amendment is flexibility. Some of us may not even know what's going to happen in the future. We need to be flexible, and we need to be able to move, and we cannot shackle ourselves. So for those reasons, I am speaking, of course, highly in favor of the Street and Zetezelo amendment. No surprise there. For those reasons. And I would ask you all to consider that in your vote. And when the time is right, I vote for continued prosperity for West Virginia and its citizens. Thank you, Mr. Speaker.
From the 50th, Delegate Pritt is recognized.
Thank you, Mr. Speaker. I am not opposed to either of these amendments. I just, by my estimation, there's one that requires a little bit more from the people that are going to get this sweetheart deal than the other one. I don't think it's unreasonable for us to demand a couple access points along this thing for our own people for them to be able to use it if the need arises. You know, we have a surplus of energy. I hear it all the time. But yet our people pay the highest rates in the entire country. And they have been for a very long time. I cannot justify to my constituents not demanding certain things from these companies when my constituents and everyone else's constituents in here have been paying the highest rates in the entire country, despite having a surplus of energy. That doesn't make sense to me. I'm not an expert in this, but I have to go home and defend my votes to my constituents. And I'm going to tell you what, they are incredibly upset about the cost of their utilities. I don't think it's unreasonable to demand more from these companies. I'm not opposed to either of them. Both of these amendments have demands. One clearly has more than the other one. That's the one that I favor. Thank you very much.
Gentleman from the 93rd, Delegate Hornby is recognized.
Thank you, Mr. Speaker. Would the gentleman yield?
Gentleman from the 50th?
Yes, please.
Does the gentleman yield?
Yes.
Gentleman does yield.
Yes.
Did you say that we have the highest electric rates in the country?
Generally the highest utility rates in the entire nation, yes.
But not electric rates?
We're close if it ain't number one.
Thank you. Thank you very much.
And, okay, you're good. Thank you.
Would the gentleman from Preston County yield?
Gentleman does yield.
Is that true?
that we have the highest electric rates in the country?
Electric rates, no. For example, let's take California. We love to compare ourselves to California around here. California is approximately 30 cents a kilowatt versus West Virginia, and I could go on and on. I have a whole list of all 50 states, but it's we are right about middle of the pack.
Thank you very much. Thank you, Mr. Speaker.
For what purpose does the gentleman from the 10th, Douglas Anderson, seek recognition?
Thank you, Mr. Speaker. I would like to speak for the second time on this bill at this particular time.
There are 2 amendments pending at this time. The chair will permit 2 debates per member on the 2 amendments. The gentleman is recognized.
I would point out to the body, as a result of the being asked to be interviewed concerning electric rates a while back, and that came in response to an article, I believe, in a national magazine. I got some statistics from the National Energy Information Administration, and I would support the Delegate Street's comments. As I recall, they're on my desk in my office, but West Virginia's electrical rates increased from $10 and something per megawatt to about $11.05 per megawatt. California's are in $30-some per megawatt. Hawaii had a slight decrease from 38 point something per megawatt down to an even $38 per megawatt. New York's is in the 20-some per megawatt. So the Delegate Street is correct in saying that our electric rates in this state are basically in the middle of the pack. We've had some increases, but not to the extent other places are across the country. And I take this opportunity to share with the body that I've already researched this, and I'm getting emails such as you from some of my constituents. But as I look at this, and I look at the statistics across the country, West Virginia is not the leader of the pack, and I don't want to be the leader of the pack in electrical rates. We have had increases, but not to the extent other states have. Without those numbers on my desk in front of me, I can't quote you state by state right now, but I've hit some of the high points, and I want to share that information with the body. Again, I support the Street-Zeteslo amendment over the Anders and others amendment. Thank you, Mr. Speaker.
Are there members who have not yet spoken on the amendments who wish to be? Yes, Chairman, the 54th, Douglas Pushkin is recognized on the amendments.
Thank you, Mr. Speaker. Briefly, just want to clear something up. Between the years 2005 and 2020, West Virginia has seen the sharpest electric rate increases in the country. If you want to go home and tell everybody, it's just your imagination, your rates aren't high, be my guest.
Are there other members who have not yet been recognized on the amendments? Chairman from the 35th, Delegate Vance is recognized on the amendments.
Hello? Can you hear me? Oh, there we go.
Yes, sir. Gentleman is recognized.
Just making sure I couldn't hear me at first. Thank you. Thank you, Mr. Speaker. Would the gentleman from the 100th yield for some questions? Yes. What would be the difference in the ratepayer protection in your amendment compared to the Zeteslo and Street amendment?
Could you, I'm not quite sure I understand the question. Can you?
Well, we have your amendment says ratepayer cost protection and proportional allocation, and it talks about no portion of the cost of construction, operation, maintenance, or financing of any electric transmission line operating at 200 kilovolts or greater may be recovered from West Virginia. I'm not going to read it all, but that part of your amendment compared to that part is not in.
Right. From the way I read the 2 different amendments, ours is a direct proportion. So if it's going to stay in West Virginia, then we as ratepayers, because I'm a ratepayer too, as you are going to be responsible for that amount that stays in the state. In the case of the Street and Zeteslo amendment, I'd recommend you ask them, but I mean, from my interpretation, It's roughly commensurate, which would be a determination by the Public Service Commission, possibly, or, I don't know, possibly the power companies would determine that what is roughly commensurate. That language to me isn't particularly clear, whereas in our amendment, I think it is pretty clear that it's going to be based on the actual percentage that is going out of the state or staying in the state.
Okay, thank you. And then another question is, you're from Jefferson County.
Sure am.
Yep. What's the average utility rate or electric utility rate in Jefferson County?
I can call my wife. I mean, it's gone up considerably. I was being facetious. I said I could call my wife. She keeps track of that and informs me damn near weekly anymore because of the cold up there and the cold down here as well. I think we're looking at like 330 plus was the last time I heard the screeching.
330 plus, man, that's a lot. I would say probably in southern West Virginia in my area, I've got little old ladies that's got $2,000, if I had $1,500 on fixed income coming in, that would love to pay a $330 electric bill instead of the $1,000 they have to pay.
I don't disagree. I'm certainly in favor of trying to lower the rates across the entire state. I mean, sure as the devil, I'm not just looking at Jefferson County. I think this is a statewide problem, and that we need to be working on trying to develop a statewide solution to this. One, to produce more energy for West Virginians and make that more affordable for West Virginians, and that's why we think that this amendment will work to achieve that.
So you think that your amendment, while it probably won't reduce the rates, but it won't let the rates go up at a fast amount?
I wish that we could lower the rates by mandate. I don't see that happening right now. If there's a piece of legislation, I'd like to co-sponsor it to reduce rates. I'm pretty sure there's a few people that would like to co-sponsor that bill. But yes, I think it will help preclude that. And again, we're not necessarily opposing any kind of expansion of our power production capability and our export of production. We just don't want to see our ratepayers pay more so that other states can benefit from our generosity.
Okay, thank you.
Yes, sir.
Would the Vice Chair of Energy yield for some questions?
Sure.
Okay, so with your amendment, will it stop? Well, I don't want to say stop because there probably ain't no stopping it, but would it slow it down? The ratepayers' expenses that they, or price hikes that they would have to occur from putting in new or from the companies putting in new installations?
Well, it is a true statement, and we've always said this. One of the reasons why rates go up in this state is we have fewer and fewer ratepayers. Mm-hmm. If you send electricity out, it will be the cost will be shared with the other ratepayers. So if we're building a ratepayer base, the opportunity for a lessening in cost does exist. If we don't have any means to get it out, it won't happen. So, because the infrastructure that we have is going to be spread over fewer and fewer ratepayers.
Okay, so do you think that your amendment and along with Delegate Street's amendment, do you think it suits what I'm asking better for your amendment or the gentleman from the 100th?
I think there's no doubt in my mind that the ability to spread the cost over more ratepayers exists with our amendment. I think the other thing is it allows for more development in the state of West Virginia. I tell you this, my biggest fear is not being able to use our resources here, send them out of state and let them do it. They're happy to. They're doing it now. We're producing 3.5 trillion cubic feet of gas, and we don't use even close to that amount. The reason is it goes out of state. It goes somewhere. It probably goes to the 18 gas-fired power plants in Pennsylvania or the 16 in Ohio or whatever. I don't want those things to happen because that is a detriment to the state. And, by the way, It's the way we've done business for over 100 years. We've sent our energy everywhere. I think we need flexibility here. I think now is not the time to start shutting off the ability to move forward with more electric generation. And I think that's what our amendment allows. So I hope that answers your question.
Okay, and so the next thing I guess I'll ask, and then I'll probably be done with questions, I guess, is where are these utility places coming in the state wanting to build these energy, or these power lines?
Power
Transmission lines?
plants?
Yes, power plants.
I'm familiar with, well, we had one that we were going to, gas-fired power plant that we were going to do in Brooke County, which was basically deep-sixed by some of the folks in the administration at the time. But there's one in Harrison County, one in Doddridge County, and probably several more will be added. Also, I have talked with some people that are looking at data centers, and they like gas-fired production for microgrids. So, I mean, that is another opportunity.
Okay, thank you. No further questions.
Gentleman from the 29th, Doug Dillon's recognized.
Will the distinguished gentleman from the second yield? I take it that's a yes. Okay.
More or less.
Thank you. Delegate, we heard a little earlier some comments about and objections to substations being required on these lines. And I believe the verbiage that was used was Field of Dreams, but my question is, have we passed in recent days legislation to expand programs such as business-ready sites?
Yes.
We have, and did we do that? Have we invested millions of dollars in the past several years for economic development without necessarily having a fish on the hook in each case?
Not necessarily, yeah.
Okay. So with that said, many of these industrial sites and business-ready sites require or benefit from off-ramps such as substations. With that said, is it still your opinion, or do you reflect the same or similar opinion as the gentleman from the 10th that these substations are a field of dreams?
As matters stand right now, it's entirely possible. But what I am saying is, just because there are no substations at this time doesn't mean there won't be in the future. That's all there is to it. I mean, I look at it as a flexibility matter. Let's get the energy produced. We have plenty of time to talk to people and get substations. That can happen. That can happen pretty much at any time, I would say. We have to work on it, you know, and we have to use our heads. But one thing we should not do is preclude more energy generation in this state. We should not do that, and I think the Ridenour amendment, well-intentioned, but I think it would do that.
And last question, and I wish I could follow up, gentleman from the 22nd, but we serve on the Joint Energy Committee together. And do you recall hearing any testimony in the last year or 2 years about the ability of the grid to accommodate the full production of all of our coal plants within the state? Do you recall any testimony stating that we had a bottleneck, that we could not disseminate the full production capacity from all of our coal plants and fully utilize those assets?
I recall some of that, yes.
My recollection is completely the opposite. No further questions. Permission to speak.
Gentleman
for the
is
second
recognized
time.
for a second debate.
Mr. Speaker, I have heard in our Joint committee and in our standing committee within the House on multiple occasions, testimony from grid operators and experts in the energy industry that we do not have a bottleneck on our coal-fired plants with regard to transmission to be able to fully utilize the capacity of those plants. These high voltage transmission lines going out of state are not a requirement. They are not necessary for us to fully utilize our coal-fired plant generation. That is not accurate. Okay, I just want the body to understand this. We have the capacity to fully utilize our coal-fired plants. With that being said, obviously I support the Anders amendment, and I believe it's the strongest amendment to protect our West Virginia ratepayers without hurting anything in industry, and in fact offering some opportunities in industry. No one says that these substations can't coincide with business-ready sites or other industrial sites. You know, sometimes you have to build the thing so that the other thing can come.
Maintaining or potentially lowering our electric rates is to grow the pie. The more power being produced and used here in West Virginia, the more customers we have, that will distribute the cost to everyone and bring an overall lower rate per customer. That's the general consensus. That's my best understanding of it. I don't know a better way to do it. How do we grow the pie? We don't grow the pie by bottlenecks were mentioned. The gentleman's correct. I was in some of those same meetings. I agree that currently, to my understanding, we don't have bottlenecks of the current amount of power leaving the state. I agree with that statement. To my knowledge, that's true. But a couple things there. We have to look at future growth. There are several planned power generation facilities in the works. Whether natural gas or whatever, regardless of the source, there are several planned facilities. So, although we may currently not have a problem getting the power out of state, we may in the future. So this is something we got to think about. And another aspect of that is West Virginia for far too long has been too much of an extractive economy. We've got to do things here with our coal, with our gas, with all of our resources, whatever those resources may be. We need more of that product used here, not just pulled out of the ground and gone forever. That's what's happened the last 150 years. We need to use more of it here. This is all part of growing the pie, spreading out the cost so that everyone can benefit from it. I know that looking at the various, these two amendments, competing amendments, it can be looked at as my friend from the Hundredths amendment as potentially having more teeth in it for the ratepayer. I think the devil's in the details on that. Again, stranded asset issues and potentially impeding the growth of bringing on new generation as far as growing the pie and that analogy of spreading that cost out. There's where I think that the amendment that myself and Delegate Zataslo are offering is a good compromise. It's a good middle ground. We're trying to look out for the ratepayer by specifically telling the PSC that they have to evaluate each of these certificates of convenience to ensure that West Virginians are getting a proper amount of benefit, some amount of benefit from it. So we're not just giving away the store. We're getting something from it. May not be perfect, but I think it's a pretty good solution, and it's the best we've got right now. I urge adoption.
Both sponsors have closed debate on the two competing primary amendments. So the procedure will be just as it was a moment ago. Chair will put the question on the first of the amendments as explained, which will be the amendment offered by the gentleman from the 83rd Delegate Street and the gentleman from the 2nd Delegate Sateslo. If you favor adoption of that amendment, please vote aye. If you favor rejection, please vote no. Once the machine is open. If the amendment is adopted, it will preclude further consideration of the two primary amendments. If the amendment is rejected, we will proceed immediately to consideration of the second of the two primary amendments. So at this time, the question is, shall the primary amendment offered by the gentleman from the 83rd Delegate Street and the gentleman from the 2nd Delegate Sateslo be adopted? Those in favor of adoption will please say aye. Aye. Those opposed will please say no. No. The ayes appear to have it. Okay, the ayes have it. Chair declares the amendment adopted. Are there other primary amendments?
Delegates Hansen and Linville move to amend the committee substitute. This is HFA Hansen and Linville 2-5 revised.
The question is, shall the primary amendment be adopted? Do the sponsors wish to explain the amendment in lieu of having it read? Gentleman from the 79th, Delegate Hansen, to explain the amendment.
This bill is about the use of advanced transmission technologies on our transmission lines. And what this amendment does is it requires the Public Service Commission to report back to the legislature on whether the use of these new technologies is actually saving ratepayers money. It's just a transparency amendment so that we have the information we need to make good decisions about reducing electric bills in the future. Thank you, Mr. Speaker.
Is there debate on the amendment? Gentleman from the 22nd, Delegate Linville, is recognized.
Thank you, Mr. Speaker. I obviously reviewed the amendment. I feel like it improves the bill, which is why I signed on as a co-sponsor to the gentleman's amendment. There's already reporting requirements for the PSC, so this doesn't generate a new report and simply provides us a little bit more information as to whether or not this can save ratepayers money. With that, I urge adoption. Thank you, Mr. Speaker.
Gentleman from the 10th, Delegate Anderson, is recognized.
Thank you, Mr. Speaker. The sponsor of the amendment presented it to me. I see that it helps the bill. I urge its adoption. Thank you.
Is there other debate on the primary amendment? If not, those in favor of adoption of the amendment, please say aye. Those opposed, please say no. The ayes have it. Chair declares the primary amendment adopted. Are there other primary amendments? If not, the bill will be advanced to third reading. Further bills on second reading.
House Bill 4089, Preservation of Hair During Chemotherapy, also known as the Jessica Huffman Bill.
Are there amendments? If not, the bill will be advanced.
Committee substitute for House Bill 4466, extend the public intoxication of alcohol code to include being under the impairment of narcotics in public.
Are there amendments? If not, the bill will be advanced.
House Bill 4474, extending the Alzheimer's Disease and Other Dementia Advisory Council sunset date.
Are there amendments? If not, the bill will be advanced.
Committee substitute for House Bill 4501, relating to dietitian licensure compact.
Are there amendments? If not, the bill will be advanced.
Committee substitute for House Bill 4695, to double the criminal penalty for anyone found guilty of sexual assault on a minor.
Are there amendments? If not, the bill will be advanced.
Committee substitute for House Bill 4767, requiring the Bureau for Medical Services to file legislative rule.
Are there amendments? If not, the bill will be advanced.
House Bill 5022, relating to expanding the programs to be included in the annual capitation rate review.
Are there amendments? If not, the bill will be advanced. Other bills on second reading? If not, bills on first reading.
Committee substitute for Senate Bill 207 has been moved to House calendar by your Committee on Rules.
Further bills on first reading.
Committee substitute for House Bill 4412, requires certain websites to utilize age verification methods to prevent minors from accessing content.
Bill will be advanced.
House Bill 725, clarifying the disposition of animals subject to animal cruelty treatment.
Bill will be advanced.
House Bill 4801, defining permissible expenditures for municipalities and counties.
Bill will be advanced. Other bills on first reading? If not, leaves of absence. Gentleman
Thank
from
you,
the
Mr.
first.
Speaker, for our colleagues, Delegates Anders, Kump, and Doug Smith.
Are there objections to leaves of absence being granted? No objections are heard. Leaves of absence will be granted. Introductions. Miscellaneous business. Gentleman from the first.
Thank you, Mr. Speaker. I move subject to announcements, the House adjourned until tomorrow, 11 a.m.
Are there announcements? Gentleman from the first.
Yes, sir. Thank you, Mr. Speaker. Your Rules Committee will meet tomorrow at 10:45 in the Speaker's conference room.
Gentleman from the 72nd, Delegate Riley.
Thank you, Mr. Speaker. Your subcommittee on banking and insurance will meet today immediately following floor session for a committee meeting. The agenda is posted. Your committee on finance will meet tomorrow, February 11th at 9 a.m. for a committee meeting and a budget hearing from the treasurer and the SBA. IMB and conservation have been, budget hearings have been canceled. The agendas are posted. Thank you, Mr. Speaker.
Gentleman from the 41st, Delegate Maynard.
Thank you, Mr. Speaker. Your Judiciary Committee and subcommittees will meet on Wednesday, February 11th in the Judiciary Committee room. The Committee on Judiciary will meet at 9 a.m. Republican members of the committee will caucus in the chairman's office at 8:45 a.m. Your Subcommittee on Courts will meet at 9:45 a.m. Subcommittee on Homeland Security will meet at 10 a.m. And your Subcommittee on Legal Services will meet at 10:15 a.m. and all agendas will be posted. Thank you.
Gentleman from the 68th, Delegate Phillips.
Thank you, Mr. Speaker. Your Subcommittee on Agriculture, Commerce, and Tourism will meet today 1/2 hour after the end of floor session in the Education Committee room. I repeat, in the Education Committee room. The agenda is posted, and Republicans will caucus in the chair's office in 15 minutes. Your Subcommittee on Government Administration will meet today immediately following Agriculture, Commerce, and Tourism in the Education Committee room. The agenda is posted. And your Subcommittee on Local Governments will meet tomorrow at 1 p.m. in the Government Organization Committee room. The agenda is posted, and Republicans will caucus at 12:45 in the chair's office.
Gentleman from the 92nd, Delegate Height.
Thank you, Mr. Speaker. Your Committee on Health and Human Resources will meet today, Tuesday, February 10th, immediately following Education Committee's meeting in the Health and Human Resources Committee room. Republican members will caucus at 3:45 in the chair's office. Also, your Subcommittee on Public Health will meet tomorrow, February 11th at 3 p.m. And your Subcommittee on Human Services will meet tomorrow, February 11th at 4 p.m. The agendas are posted.
Gentleman from the 43rd, Delegate Tony.
Thank you, Mr. Speaker. Your Subcommittee on Public Education will meet today at 3:30 in room 215E, the East Wing Committee room. Your Subcommittee on Educational Choice will meet today at 4:30 in room 215, the East Wing Committee room. Republican members of the Subcommittee on Educational Choice will caucus in Gov.org offices at 4:15. And lastly, your Standing Committee on Education will meet tomorrow at 1 p.m. in the Education Committee room. All agendas are posted.
Gentleman from the 2nd, Douglas Teselo.
Thank you, Mr. Speaker. Your Standing Committee on Energy and Public Works will meet today at 5 p.m. and tomorrow at 3 p.m. in the House Judiciary Committee room. Both agendas have been posted. Now, let me restate that. Today, we will meet at 5 in the Judiciary, and tomorrow we'll meet at our usual 3 o'clock. So we'll look forward to seeing you.
Gentleman from the 59th, Douglas Shamlin.
Thank you, Mr. Speaker. Delegates Young and myself invite all lawmakers under the age of 45 to join us immediately after floor session for future caucus. Lunch will be provided. And then for everyone in the body, there is a bipartisan bowling night for all legislators and staff. You have that information on your desk. Hope to see you there at 6 o'clock.
Are there further announcements? If not, the questions on the motion that the House adjourns at 11 a.m. tomorrow. Those in favor of the motion, please say aye. Opposed, please say no. The ayes have it. The motion is adopted. The House is adjourned at 11 a.m. tomorrow.